That is pending, my lord, long, my lord, retired lady, my lord, and my lord, poor lady. You lost the hardly matter, my lord, on length, my lord, but our argument is complete, my lord, but the other side is always, my lord, argument. Yes, my lord. Yes.
My lord.
Okay, it is not 29. Current law itself contrary to the Act of 1962.
Application for restoration.
My lord, upgradation, my lord. It is in the monthly list 951, my lord. Matter is most urgent, my lord, because private respondents are making construction over the PW lane, my lord. My lord, deeply obliged.
The land of the petitioner was the item taken in the year 2009 until now.
Application for extension of interim order.
May my lords kindly, my lord, to mention, my lord, for upgradation, item number 687 of your lordship's monthly list, my lord. The urgency is, my lord, I was, my lord, the highest bidder in a tender, my lord. I deposited 94 lakhs of sum, my lord. Thereafter, my lord, this tender was challenged before the court and was set aside, my lord. So, my lord, I prayed for refund of my money, my lord, 94 lakhs, which I have till date have not received, my lord. I'm a senior citizen, my lord. I need money for my own treatment, my lord. I just oblige, deeply oblige.
My lord, mentioning for
Upgradation, Achota.
my lord.
The last order, your lordship, of 28 April. Your lordship, Monday, if it is getting passed by your lordship,
The lordship
can be fixed in a letter. The only difficult because we never know
I'm sent to arbitration matter, my lord. Urgency there, my lord. This is my land. Registered it is there. The Israel authority is saying it is my their land. But I have filed an application. It is kindly give me answer whether it is the land. Well, they are saying no, it is not their land. But they are trying to demolish my one.
My lord, mentioning for upgradation, my lord, the 84 years old widow is the petitioner, and this is the second writ petition, my lord. The first writ petition was disposed of by direction upon the state authority to dispose our representation. The fact has been admitted that illegal encroachers is there, but ingress and egress of my land is totally blocked, my lord. My lord.
For upgradation, your lordship, the urgency is the property is a lease property which will be given out some other by way of an auction, your lordship. And this is very small matter, just for consider the represent.
land, Lord, private respondent have constructed Lord a portion Lord of their house extended. Now, Lord, I filed the writ petition, Lord, recently, Lord, there again, Lord, extending the construction. So matter is very urgent, but 254 I can.
Item number 4 of the month. My lord, item number 654 of monthly list of June 2023. This matter is upgradation. Ma'am, actually my senior learned advocate is Madhurima Sarkar. Okay, ma'am.
Well, extension of interim order, well, interim order will expire on 15th July.
My lord. May I mention? Illegal construction, monthly list 946. There are 3 matters. In front of the petitioner land and PWD land, the unauthorized construction. Grateful, my lord.
Daily list item number 1.
Lord, I appear for the game. No, for the state, my lord.
This is my lord. My lord, this is an application for extension of interim order. My lord, on 27th of February, my lord extended the interim order till 30th April. But subsequently, my lord, it was not extended, my lord, I missed it. And on 6th of this month, matter was listed when my lord found that since the interim order has expired, therefore my lord has been pleased to fix the matter for hearing on 28th of June. And my interim order was not extended as no application was filed. My lord, I have filed the application, kindly extend the interim order, my lord, for a limited period. My lord, no, my lord, I have prayed that it may be reimposed and extended. My lord, the challenge in the read is, my lord, order of demolition.
Matter is already
Kindly
fixed on
If your
28.
lordship-
my lord. You're
My
already
lord,
fixed
if
on the
your
earlier.
Also, I oppose reimposition of.
No, my lord, kindly come to page 51. My lord, kindly come to page 151. My lord, kindly come to page 151 of the read petition. What I have challenged in the read, their direction, my lord, to demolish the last 2 lines. Page 151 of the read petition.
Yes,
And my
Chair,
lord, not only that.
admittedly, the read
আমি বলে নি,
petitioners are post-vesting transfer having no right.
দাদা আমি বলে নি, তারপর আপনি বলবেন। একসঙ্গে দুজনে বললে জোসেফ কারো কথা শুনতে পাবে। পেজ 151, last 2 lines. Police has been asked to, so I would therefore requested on behalf of the KMDA to take drastic steps. My lord?
2020.
Yes, 2020. Therefore, since 2020, there is an interim order. Since 2020, my lord, the interim order is going on. My lord, initially, the interim order passed by Justice Orijit Banerjee. Thereafter, Justice Vishwajit Basu, it was extended on 23rd of February 2021. No, my lord, kindly extend the interim. Why, my lord? I am sorry. My lord, on 28th, what will happen? We do not know. I may not be there. I may die in the meantime. My lord, nothing can be said. My lord, on 28th, my lord, it may be there not to attend. My lord, everything may happen. My lord, kindly extend the interim order for a limited period.
I oppose this. My lord, with the similar prayer, another writ petition was moved prior to this writ petition on the self same. And in that writ petition, interim order was refused by my lord Justice Boshak. This is the order. And thereafter, the matter came up for hearing before my lord Justice Orijit Banerjee. And the matter was heard. Mr. Basu, this is the order. In past, in earlier, that was filed in residuary jurisdiction. That too challenging the notice,
It is a different matter.
identical notice. And if your lordship kindly looks to the order initially passed in this writ petition on 4th February, lordship will find that why that protection was given. The petitioners are admittedly post-vesting transfer having no right to challenge the acquisition proceeding. And in fact, acquisition proceeding has not been challenged. In our affidavit, we have disclosed that the land in question is acquired. And everything is complete. Payment of compensation has already been made. At best, what he can get. Nothing apart from compensation, if at all entitled to.
The proceeding has lapsed.
Lapsing, that too was not challenged. My lord kindly sees the prayer. Acquisition proceeding has not been challenged in this writ petition. How he can say? The court will mold everything
Department has stated my name in respect of the land.
without challenge to the acquisition proceeding. What he is claiming? He is claiming to occupy the acquired land of the government. My lord, I beseech your lordship not to pass any such order. Let the matter be heard. Because taking advantage of status quo, lordship will find, lordship had to pass a protection on 10th December. Lordship, kindly have a look.
10th December.
10th December. Taking advantage of that, he was trying to make construction. That is why on 10th December, Lordship was pleased to direct the police authority to look that the order is complied with.
My lord, may I pray one thing, my lord? My lord, 28th is Ulto Roth. My lord, before 28, before 20. All right, my 28. All right, kindly extend the interim order till 28. Fourth of February, 2021.
My lord, lead the rider first by, given by your lordships earlier, 10th December order that.
Yes,
that-
yes, I have no objection.
10th December order. 10th
10th
December
December.
2021.
My lord directed the police authority to ensure the
Ensure.
order of status. I have no objection to that.
Because time and again, taking advantage of this order, my lord, he is trying to make construction. And we had
But
to
one
lodge several complaints with the police authority.
দেখছেন আমি তো আপত্তি করিনি second page most probably my lord.
Second place,
Last but
10th
one
December
Review of
2021.
the same. The respondent number 7 is directed to ensure strict compliance of the order of status quo by both the parties.
Yes.
I am grateful.
The writ petition itself is not maintainable. We have taken the maintainability point.
আচ্ছা
স্যার।
ওইটা আপনি বলুন আপনি কি ওইটা আনতে
কোনটা?
চাইবেন তাহলে ওটা অ্যাসাইন করাতে হবে কিন্তু আরেকটা ম্যাটার যেটা দেখাচ্ছেন তাহলে এখনই বলুন
আমি অ্যাসেন্ড করবো কেন? আমি তো ছিল একসঙ্গে। তুমি তো
বলুন
এটাকে
সেটা।
আলাদা করে দিয়েছো। Earlier
আর
these
এটা
two
বলবো
writ
না।
petition were appearing together.
How that can be? That was a residuary matter.
That residuary, and that is why on
Unless
their
there is
prayer
an
that was segregated.
Unless there is an assignment, it cannot be.
That assignment, they had to assign, pray for assignment.
Item number 2.
May I take back the order? We ordered it to do the.
My lord,
My lord, in this matter, I am applying for the petitioner, my lord.
my lord, in
There is some requirement, some time, my lord. We will sit together, my lord. We'll try to find out the original IGR. The DSR is here. Malad, they will assure us they will try his level best and they will Malad, giving some time. If your lordship kindly giving some time, then your lordship kindly they will find out the official idea. I think the problem will be solved. Malad, then your lordship kindly fix the matter. Malad, end of July, August.
My lord, the
In-
deed
first week
he
of
is claiming is a different deed, actually.
So
Totally
that
different.
argument was over.
Over, yes,
That
yes.
argument was
That's why
over.
Yes, yes,
Yes, yes,
The
yes. We
SR
will
has
sit
searched
together,
his,
my lord.
searched his records and found that this is a different deed, what he is
But
claiming.
last Thursday, we
But
will sit
shown-
together, my lord, the
shown
DSR
to-
office, in the DSR office, we'll try to
My lord,
solve the,
Mr. Nilotpal Chatterjee is appearing for this case.
my lord, first week of August, any day, my lord. 10th August. Yes, 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 ma'am.
10th
10th August. In
My
the
lord.
meantime, we'll sit together, we'll try to find it out. If they will find it out, then
Deeply
my lord,
obliged.
the matter will be solved, ma. The petitioner is going here and there, my lord. They will not get their, my lord, registered.
Yes,
my lord.
yes, my lord. Yes,
I am grateful to your lordship.
deeply obliged.
Item number 3,
I prefer the Union of India in this matter. I am for that. Lordship. Yes, come. I have already completed my argument, file notes of argument also, Lordship. For recalling the Lordship's order in the ground of fraud and misleading the court.
Lordship, I'm appearing for the petition in this matter being led by Mr. Majumdar. He's currently stuck before another court. If you could kindly grant a short passover. Lordship, in that case, I'm praying for a not today because he stuck before another court.
When, Lordship, then? Yes, Lordship. Grateful, Lordship.
Grateful, Lordship.
Grateful.
item number 4, new motion.
But here I am for the petition. Alright, this is my service. Right. The private respondent, well, I have just. The private respondent encroach upon the PW. Yes, yes, confirm. Confirm, my lady.
Split for split.
I do not find. It's the Mahatma. Yes. Given system, my lord, that the property belonged to my father. After death of father, I am the property original belonged to my father. Well, after death of my father, my lord, I become one of the legal heirs and along with other legal heirs. My lord, we are enjoying the case suit brought. But what happens, my lord? The private respondent suddenly started construction upon the PWD land in front of my land. My lord, kindly see the photographs. My lord, I've annexed submitted representation, my lord, that is page 49. But kindly see page 49. Representation has been given, my lord, to the authority concerned, but no steps have been taken till today. But if your lordship call for a report from the PW, that will be better, my lord. My lord. Because if it is found in the really this construction is going on the PW land. Yes, yes. They will demarcate with the help of BLRO. Your lordship will kindly, if this make this observation subject to lordship approval, if they will demarcate that plot of land, and if it is found that it belongs to PWD, they will take steps in accordance with law. I can watch out. I'm thinking.
অনিরুদ্ধ সেন
হ্যাঁ অবশ্যই আমি অ্যাটলিস্ট ফোন নাম্বারটা একটু দিয়ে দিলাম এখানে 5 and 6
অনিরুদ্ধ সেন 11 নম্বর
11 নম্বর Thank you. Five and 6, one of the subject to illustration.
On 22nd November 2022, which is yet to be considered. Stop, the petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents. You have not implemented the assistant engineer?
No, executive engineer has.
Assistant engineer is the
Madam,
authority.
can we leave to her?
Yes, please
Assistant
implement the
engineer.
assistant engineer. একদম শুরুতে করুন, on prayer of the petitioner, liberty is granted to implement the assistant engineer, Public Works Department, Kakdeep subdivision, as respondent number 12 in the writ petition. Paragraph, the cost title of the writ petition be amended accordingly. Okhane, it is submitted on behalf of the state respondents that the 12th respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the 12th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of, which are.
My appointment is regular.
Yes,
My appointment is regular.
yes, it is regular.
Copy.
Item number 5. I'm appealing for the statement. I'm for the petitioner. But I have received 2 instructions, one from the OC and one from the engineer. I served upon all the respondents, this is effective, including the private respondent. Private respondent, page number 11, madam.
Give me. You are appearing for the state, madam?
I'm filing the report.
Yes, what is the matter about?
Contamination of the original Highways Act 1964, madam. The district engineer.
The authority has admitted the case of the petitioner?
My lord, yes, madam.
Yes. So why haven't they taken steps for removal of the construction?
Let the representation be considered in accordance with law.
The demarcation has not been made as yet.
No, ma'am, nothing.
So let the proceeding be concluded within a stipulated time frame.
Yes.
Affidavit of service. None appears for the private respondent despite service. Paragraph. The petitioner alleges unauthorized construction made by the private respondent by encroaching upon a portion of the PWD road adjoining his property, comma, thereby obstructing his egress and ingress. The petitioner submitted a representation before the concerned authority in this regard. Page
33, my lord, 32 and 33.
on October 2022, which is yet to be considered. Paragraph. It transpires from the instructions submitted on behalf of the state respondents that pursuant to the representation submitted by the petitioner, comma, the assistant engineer, comma, Holdia Highway Subdivision, comma, PW within bracket roads directorate, comma, by a letter issued on 2nd February 2023, comma, 2023 to the Block Land and Land Reforms Officer, comma, Mohishadol, comma, Purbo Medinipur, comma, requested demarcation of the allegedly encroached land. Stop. It is submitted on behalf of the state respondents that such demarcation is yet to be completed. Paragraph. In view of the above, comma, this court is inclined to hold that since steps for demarcation have been taken by the concerned authority pursuant to the representation submitted by the petitioner, comma, the concerned authority, comma, being the
Respondent number 3, my lord.
third respondent herein, be directed to initiate proceedings under Section 10 of the West Bengal Highways Act 1964 in the event unauthorized, encroachment upon the PWD road is detected upon demarcation, and take the proceeding to its logical conclusion within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, comma, in accordance with law. With the above instructions, the petition is disposed of, which actually. Yes, next.
Item number 6. Would I appear for the petition?
You missed the bus, sir. I'm sorry.
But item number 6, my lord, I appear for the respondent numbers 4 to 12.
You're appearing for?
Respondent numbers 4 to 12, my lord. The private respondents, my lord, the beneficiaries of the will of Srimati
What
Poola.
about the others? 1 to 3? Have you served?
Yes, madam. Receipt করেছে তো? Have they received? একটা কপি আছে? Executive service. But item delivery confirmed, my lord.
Yes. But I don't find anyone representing them. For the state also.
My lord, here, my lord, the respondent number 3 is the relevant respondent. Yes. We had a short point, my lord, which has been decided by the Odisha High Court, then, my lord, the Supreme Court, as well as by this honorable court.
Siddhartha, I'm afraid. When did you serve actually? Because
I was there.
6th February, long back. But can we deal with the matter in absence of the respondents?
I don't think so.
So will you serve a fresh notice?
Very good. May I come back next week, next Friday?
Can you serve by in the meantime?
Yes, yes. We'll try to serve by hand delivery this time.
Affidavit of service. None appears for respondent numbers 1, 2, and 3 despite service. A paragraph on prayer of the petitioner, liberty is granted to serve respondent numbers 1, 2, and 3 afresh and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 20th June.
Great.
But please direct that we should serve, my lord, the government leader. Because once the matter is taken up, the office,
Generally serve upon the government.
yes,
leader
that is
only.
as per the rules. I'm grateful.
Great.
Next.
7, my lord, I am for the petition.
Item number 7.
My,
I for the state respondent, my lord.
that's almost similar to item number 4. Upon my,
I am
in
for the
front
private
of my
respondent.
plot of land. My lord, the private respondents, my lord, occupied the PWD land for which I am suffering a much. I made representation.
Is it
before-
PWD road?
PWD road, in front of my PWD road. In my adjacent to my plot. Several shops have been constructed and my lord, kindly see my
Have you,
representation.
you are appearing for the private respondent?
Private respondent.
Where is your representation?
Page 37, my lord. Only one thing, my lord, the assistant engineer has not been made party, if you lordship grant me leave.
It's not been made party.
No, my lord, if you lordship grant me leave, I shall.
What been
Our
made party and no
representation is-
representation also has been sent to the
Representation.
Can
No,
you
no.
see? Read.
No, no.
Name is written, but
It
my
has
lord,
been sent to the assistant engineer, but
Sent.
not made. Letting be
I
happen.
would have not said, my lord, kindly see the, my lord, next page of the 39, the postal receipt. No document has been annexed to show that the letter has been sent. Sent to SDO, DM, executive engineer.
Let there be a direction from the court. No difficulty. That's technical.
Kindly, my lord, submit a face representation.
Why?
Madam,
Let this
no,
be considered. He'll serve a copy.
Definitely, my lord, but
He'll serve a copy. Why are you technical, sir? It is already there on record. Yes, does the private respondents have to say anything?
No, not kindly not send it for.
You'll be given an opportunity of
Yes,
hearing.
ma'am. Yes, ma'am.
Affidavit of service.
private respondent number.
Oh. On prayer of the petitioner, liberty is granted to
Assistant
implement
engineer,
the
Lokhi
assistant
Gantapur
engineer,
Highway-
public works department, Diamond Harbor.
No, Lokhi Gantapur Highway Subdivision, PWD Road, South 20, Sarbala. That is page 37, last.
Assistant engineer, Lokhikantapur Highway Subdivision, comma, PW within bracket roads, South 24 Parganas, as respondent number 28 in the writ petition. Paragraph, the cost title of the writ petition be amended accordingly. Paragraph, the petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon a portion of the PWD road adjoining his property, comma, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation in this regard before the concerned authority on. What is the date of your representation?
Undated.
It has not been named.
25th
After that,
November
my lord,
2022. The postal receipt state. On 25th November 2022, which is yet to be considered. Stop. The petitioner pays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the state respondents that the 28th respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the 28th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law.
And pass it.
Yeah. Yes,
To pass it is in order.
obviously, if they consider, they have to pass an order. Disposed of which
Liberty is granted to act.
I have granted.
Grateful to this.
Grateful.
Item number 8.
8, my lord, I beg to differ on behalf of the petitioner, my lord. This is my,
I am for the private response.
this is my affidavit of service.
I would only request the petitioners, my lord, after upgradation, they should give us notice. There is appearing,
Not given?
no, my lord.
This is difficult, sir.
Very difficult, my lord. I need some instruction in this matter.
It's a very short matter, my lord, encroachment of my
Maybe,
lord.
but it is your fault. You should have served. You should have intimated the other side. You miss a date.
Very
Want to
short.
come back with
Yes, my
instructions?
lord.
Let him, my lord, may
Affidavit
kindly
of
be
service.
on very
The-
short
But
date.
I
my
am
lord.
appearing for not
Paanch jon,
only
paanch
some of 14, 17 and 18.
19.
And 19.
Ekjon
Other
Respondent numbers 14,
17 and 19. my lord.
17 and 19 seeks accommodation to take instructions in this matter. Paragraph,
Only
let the
15
matter
is left.
appear under the same heading. The others are served.
My lord,
Have you checked?
my lord, yes, my lord.
Presence of national high authority is not necessary.
So the allegation is against the national highway.
National High Authority, land belongs to my lord PW.
You have not implemented the national. Highway?
National Highway Authority is not a party to the proceedings.
Please do that in the meantime. Yes, to save
Sir,
time.
kindly grant me the liberty, my lord.
কি বললেন? He seeks to take instructions. তার আগে একটা line করুন. On prayer of the petitioner, liberty is granted to implead the National Highways Authority. Give the entire nomenclature.
My lord,
Entire
Give the
nomenclature.
entire nomenclature, National Highways Authority of India, then which jurisdiction?
my lord, that
Petitioners.
service through
National Highway Authority, service through the competent authority, the central government.
it's reflected
The
as
regional
competent,
officer has been implemented. Respondent number 6.
my lord.
দরকার নেই, কেটে দিন. Not necessary. Further. Please ensure service. That's all.
My lord, all have served, only my lord,
Liberty
the
taken.
superintendent of police, I have checked it, my lord. The superintendent of police and my lord, the, they are appearing, my lord, on behalf of the state government.
Notice of upgradation.
Yes.
সেটার জন্য বললাম তো।
Absolutely, that is what he said. Absolutely.
That is why I think.
And the petitioner suffers. We could have taken up the matter today if he would have served. Anyway, instructions in the matter, paragraph, let the matter appear under the same heading. On 29th June.
20. Great.
29th.
Item number 9.
This for the state.
Yes.
I don't know, Mr. Chondicharan, this for the state.
One for the petitioner. None appears for the petitioner. No accommodation is sought. Let the matter appear under the same heading on 20th July.
20 July, huh?
20.
Item number 10, I beg to appear on behalf of the petitioner. But this is my affidavit of service. But the plot number is
Who
2753.
is appearing for the respondents?
I am for the state authorities led by Mr. Ashim Kumar Ganguly.
But the plot number is 2753. But there, out of 2.22, 2.17 acre was being acquired. The compensation paid, section 18 proceeding was being initiated. Kindly once looks at section
Have you
18
served
proceeding.
the private respondents?
Here, the private respondent is also the pro forma respondent. This is
So
one
there's
of
a
the,
private respondent also. Cooperative producer, cooperative petitioner number.
that is the requisition body.
Where's the
Perhaps
service? Not there.
Is
It's only upon the state. Serve and come back.
But here, only the answering respondent is the state. Why, may I show before your lordship once?
Expunge their names. You cannot. So you have to
That
serve. So you have to serve.
service code as
Serve both of them for abundant precaution. Serve and come back.
service code.
Since service upon the private respondents is not complete, let the matter appear under the, let the matter stand over till 30th June.
30th June.
Please, please serve in the meantime.
Very good.
Item number 11. I am for the petitioner, my lord.
Well, I am for the private respondent number 8.
State.
Adjacent to my plot, my lord, there is the PWD land. That
Who is
land-
appealing for the state? Mr. Dey, you are just in time.
Yes, my lord.
I request you to appear. I was wondering what is wrong with you.
Adjacent to the petitioner's land, there was a PWD
Please serve
land.
a copy to Mr. Dey.
My- There was a PWD land. That land was enclosed by the private respondent, my lord. I made the representation. Thereafter, I filed the writ petition. After filing the writ petition, my lord, the BLRO demarcated the land. Thereafter, nothing was done, my lord. The representation at page 49.
Demarcation is done.
Is done, my lord.
What is the result of the
I
demarcation?
don't know, my lord. Representation at page 49, my lord.
Petitioner, the respondent house is a kacha house. Might you see the photo?
Respondents?
Staying in a kacha. In the plastic set. And petitioner land after Loanjali. Main road.
Make
Then-
your submission before the authority.
Respondent number.
Mr. Dey, let it be. considered. Representation is at page.
Page 49, man.
Assistant.
Affidavit of service, none appears for the state respondents despite service. Mr. Dey service regularized couldn't. Copy service and direction B. The petitioner complains unauthorized construction made by the private respondent by encroaching upon PWD road adjoining his property, thereby obstructing his egress and ingress. The petitioner submitted a representation in this regard before the concerned authority on 6th February 2023, which is yet to be considered. Stop the petitioner. Paragraph code. It is submitted on behalf of the petitioner that pursuant to the representation, a notice has been issued by the Block Land and Land Reforms Officer, Egra Roman 2, Purbo Medinipur, on 23rd March 2023 for demarcation of the plot in question on 30th March 2023. Stop. No further communication has been received by the petitioner in this regard. Paragraph, it is submitted on behalf of the private respondents that the private respondent has been residing
In a
on a kacha road,
mud house
residing in a mud house.
with plastic cover.
That is your own land.
Yes. Huh?
Is it
No,
your
no,
own?
no, 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 no.
Not necessary. Land.
That will not be.
It will amount to your admission, sir. It is submitted on behalf of the state respondents that the
Respondent number 4, man.
fourth respondent be directed to consider the representation submitted by the petitioner dated such and such in accordance with law. Paragraph, in view of the above, this court is inclined to hold that since notice of demarcation has been issued by the Block Land and Land Reforms Officer pursuant to the representation submitted by the petitioner, the concerned authority, being the fourth respondent herein, be directed to take necessary steps under Section 10 of the West Bengal Highways Act 1964 in the event encroachment upon PWD road is detected upon demarcation, and take the proceeding to its logical conclusion within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, in accordance with law.
My lord,
Disposed of which act?
on indulgence, my lord, at the time of all the item 9, my lord, I was engaged in code number 22, and therefore, my lord, in contempt proceedings, my lord. Therefore, I am not in a position to come before your lordship. My lord, kindly take up this matter.
Item 9, an order has been passed. Item 9, some order has been passed, sir. I cannot say what has happened. Please come back. Yes, next.
Item number 12. Item number 12, my lord, I appear for the petitioner, my lord. I beg to appear for the state respondent. At page 82, it's my lord's order, my lord. Thereafter, my lord, the contempt application was taken up, my lord. The
Respondents, where is your?
no state respondents, my lord, I appear on behalf of the state respondents. But 82 is my lord's order, my lord. Thereafter, my lord directed for the payment of compensation, my lord, although, my lord, the statutory benefit part was not mentioned. Thereafter, my lord, we have filed a contempt application, my lord. During the pendency of the contempt application, page 84 notice was issued, my lord, upon the claimants, my lord. My lord, for notice for submission of the requisites document and bank details in connection with the payment compensation. Thereafter, my lord, some payments have been given in our accounts, my lord. But difficulty is, my lord, no payment notice, no details of the calculation has been given. We cannot proceed with the reference, my lord. Accordingly, page 88, my lord, we have given them a letter, my lord, saying that we are not happy with the compensation, my lord, and we need to proceed with the reference case, my lord. But unless the details are given, my lord, under which act? Section. Because our claim was, my lord, under the new act 2013 act, my lord. Lord, there is a provision for appeal, my lord, I believe. If he is a
Provision for appeal of which order?
No, my lord, he's submitting about reference, my lord. That he's saying that it's happy.
Yes, they want to go in for reference. What is preventing you?
My lord, unless the details, my lord, prayer, my lord, page 20, my lord, we have stated the, unless the details of the compensation money, my lord, is given and the, my lord, the payment notice under which act it has been given, my lord, 12 to, my lord, details are to be given, my lord. Unless that is given, my lord, only some amount has been sent to the bank. Reference cannot be done, my lord, in that manner, my lord.
No payment notice, nothing. Account is not.
Banking account is but that is to be given, my lord.
Page 88 would be considered, my lord. Page 88.
Page 88 is only an objection. It is,
Yes.
It is different from your prayer A. Prayer A and page 88 are different.
My lord, prayer A, we have page 88, my lord, আপত্তি সহকারে গ্রহণ করিলাম নিম্ন স্বাক্ষর যাতে আমরা নতুন আইনের ক্ষতিপূরণ অর্থ পাই। মানে that is, my lord, in relation to 2013 act, my lord, we in the earlier writ petition we prayed for 2013 act. My lord, they have thereafter given some amount, but under which act, my lord, they have not disclosed. And that is why, my lord, in any way we have to go for a reference, my lord, since some amount has been given, my lord, and the benefit has to be considered, my lord, in that, under that act only.
So let the writ petition be allowed in terms of prayer A. That is what actually you're asking.
My lord, my lord.
The representation will not really help. Isn't it? Your representation will not help. Disposal of the representation will not.
But let the details be given, my lord. That's
not
great.
serve your purpose.
My lord.
That is not stated in your representation at all.
But
Isn't it?
given by my lord.
So let it be prayer A.
My lord.
My lord, only details.
Prayer A.
Prayer A, only details.
Affidavit of service. Pursuant to an order passed by this court on October 1, 2021 in WPA 17704 of 2019, directing the state authorities to disburse the compensation amount assessed in favor of the petitioners within a period of 4 months from the date of communication of the order, comma. Notice was issued upon the petitioners for submission of requisite documents and bank details in connection with payment of compensation. Stop. Paragraph, it is submitted on behalf of the petitioners that some amount has been deposited in the bank account of the petitioners as compensation, but the petitioners are unhappy with the said quantum. Stop. The petitioners seek a direction upon the concerned authority to release the details of the compensation paid to them. That is what you're asking for. In connection with LA case number Roman 2/21 capital A of 1980-81. In order to enable them to take necessary steps for enhancement of the compensation. Paragraph. Upon consideration of the submission made on behalf of the parties, comma, the writ petition is allowed in terms of prayer small a. Chatteling. Paragraph. Who should furnish the details? Collector. Additional land acquisition officer?
Two, my lord.
Yes.
Most probably two.
The district magistrate.
District Magistrate and Land Acquisition Collector.
The special land acquisition officer, South 24. Three.
The paragraph, the third respondent is directed to act in terms of prayer A of the writ petition within 2 weeks. Just the details are to be given within 2 weeks from the date of communication of this order. Disposed of.
Item number 13. 13, Mala, I am for the petitioner. First of all, Mala, I beg your lordship's pardon, Mala, I mentioned the matter for upgradation. Your lordship, please do upgrade it, but I have not served the notice upon my learned friend, Mala.
That delays the matter, isn't it?
Mala?
Ultimately. That delays the matter ultimately.
Mala.
Are you ready today?
No.
This is what happens.
Matter was appearing in monthly pictures.
Yes, I- You're appearing for all the respondents?
There is a private respondent, I have served.
Where is your service?
I have served, Mala. They have received. Item delivery confirmed.
Where is your affidavit of service?
Mala.
It's confirmed.
Confirm, Mala.
Let there be another date. He has to take instructions.
I will inform them also, the private respondent.
Affidavit of service, none appears for the private respondent. This is the pro forma respondent, not the
Pro forma
private.
respondent.
None appears for the pro forma respondent despite service. Paragraph, learned counsel for the respondents seeks accommodation to take instructions in this matter. Paragraph, let the matter appear under the same heading on 10th July.
My lord, I beseech your lordship, fix a early date because, my lord, 27th June is the date fixed for recovery of the money. What I have challenged before your lordship, Lord, the certificate proceeding. This is, may I hand over the certificate notice? Lord.
This pertains to land.
Land. The 27th June is the date fixed, my lord.
You've been directed to appear and place your documents.
No,
So isn't the writ petition premature?
no, my lord. Prior to that, your certificate has been issued. I have challenged the certificate.
Attend the hearing, see what happens, let the
So
date be after that.
certificate has been issued for payment of a money. My lord, the certificate, my lord, may I humbly submit the certificate, the amount has been written there. No clarification is given how the amount there is. The section says there must be hearing prior to that, prior to issuance of the certificate. I will satisfy your lordship.
All right, but then without, why don't you appear before the authority first?
I
see
will,
what
my lord, I will,
happens,
but I will be
and
compelled to.
fix a date immediately after this.
No,
Let it be
I will
30th.
be compelled to pay the money, my lord. I have challenged this proceeding before your lordship.
You will be compelled to pay maybe after the hearing is done, isn't it?
No, certificate is issued for payment. Certificate has been issued and direction has already been issued for payment on 13/2/23. Thereafter, I filed the writ petition. That is before your lordship. Thereafter, no notice was there. This notice has been issued on 31st of May for appearing before 26th of June. I received recently, and thereafter I mentioned before lordship.
Have to give an explanation as to why you did not pay the amount, isn't it? This is the notice. So why don't you, I think it will be better if you attend the hearing and then come.
But kindly fix a date so that I can satisfy your lordship.
On 27, come back on 30th.
27th, the date fixed, my lord.
Yes, I want you to attend I suggest you attend the hearing.
Okay.
Because you will not be compelled to pay on that day. You can, might as well tell them that the
My
court
lord.
case is pending.
But then clarify that, my lord. Kindly clarify that in your order.
Not required. I cannot ask you to, that.
No,
that clarification-
your lordship can ask me to appear before the authority on 27th.
It is, how can this court direct you to appear before the authority? If you wanted it earlier, I can give you, but then this will be my recording on that date also.
But
That you have to appear before.
then my lord on 30th.
Yes.
On 30th.
Because this
My
is
lord.
27. Come back
As your
to
lordship, as your lordship.
let the matter appear under the same heading on 30th.
Great. This is June. Sundar Rampadu. Sundar.
Item number 14. I am for the petition, my lord. In view of the urgency, I had to mention the lordship. Matter was heard on 10th of April. Before that, my lord, this order was fixed by your lordship.
That was in connection with another.
Yes,
matter.
yes. Same. It is in the, just in the order. না দেয়া নেই এটা দেয়া নেই
এটা কেন দেওয়া থাকে? এটা
I
অন্য
come
matter-
I come মানে the instant matter is the second notice in by tender. The first notice in by tender was challenged. Only your lordship was pleased to admit the petition on 31st of March. But during the pendency of that matter, second notice has been issued and they are trying to create third party interest. For that reason, I have to come. My prayer, my lord, your lordship kindly hear both the matters on any day so that matter can be resolved. So the matter.
Your lordship, so far as the second tender, I don't know where from he is submitting. This is from the bar. If your lordship kindly peruse the document, on 31st, 23rd of March, the tender was invited. And the writ petition was moved on 31st of March.
It was decided, my lord has
He challenged a tender which was conducted and cancelled in 2017. In 2023, he challenged that 2017 cancellation order. And the subsequent writ petition that was filed challenging another tender which was invited by WBMDDCL on 23rd of March 2023.
That is in the present writ petition.
In the present writ petition.
The
I
second-
know where, what is he saying that
Second
second
writ
writ petition,
petition,
first
my
writ petition, the first tender, second tender, where from he is submitting? I fail to understand.
I have annexed those documents. I have annexed both the documents.
And so far as the first writ petition is concerned, I have submitted my report. He also has used
No,
his
no, no,
exception.
report,
Your
because-
lordship can take up this
Yes,
matter.
that is my prayer.
That
Both
is the
matters
main
may be
issue.
heard. That both the matters may be heard.
That is what his submission.
I am
is.
praying
Both of
that-
them will be heard together. When
Yes.
is the other matter fixed?
My lord, your lordship,
This on the same day.
my lord, your lordship,
Your lordship can take up the matter on any day.
on any, my lord, your lordship, it was fixed on 20th of April. My lord, could not
After
have,
that, after that,
after that matter could not
Lordship
appear.
matter was not taken. It was there in the list.
so
Because,
let both the matters appear together on some.
yes, yes,
particular
that's
day.
my prayer, my lord.
It is submitted on behalf of the petitioner that another writ petition being WPA 899 of 2023 pertaining to a similar issue as in the present writ petition is pending. Learned
Sure.
counsel. Submits that both the writ petitions be taken up for consideration together. Paragraph let both the writ petitions appear under the same heading on 10th July.
Man.
899 of 2023.
My lord, only prayer, if your lordship, no third party interest may not be created. My lord.
Lordship, if it has already been created, Lordship can grant status quo as on date.
But although the case has not been made out to that, Your Lordship, will take up the matter on 10th July. Because
Next.
if my landlord says so, I have nothing to say. He,
Next.
item number 15.
My lord, I am appearing on behalf of the respondent 18.
The state.
Petitioner. Is the portable for the state?
I'm the state. My lord, my case is, my lord, running of unauthorized.
Microphone
over the land of the
Take the
petitioner.
microphone, please.
My lord, running of unauthorized brick field over the land of the petitioners, my lord. My lord, there are statutory provisions under the Act, my lord, West Bengal, my lord, or Minerals Rules 2002. My lord, quarry permit is necessary, my lord. My lord, time to time, state government issued guidelines, my lord, regarding environmental policy and others, my lord. Without taking any, my lord, they are running forcibly, my lord, brick field over the land of the petitioner. That's why I made, my lord, complaint before the lastly, my lord, complaint before the concerned authorities to take effective measures in the matter, my lord. Page 28, P3, my lord. My lord, not yet, my lord. Any positive steps taken by the said authority, my lord.
Where is your application?
My lord, application, my lord, to page 28, P3. The district land and land reforms officer is the appropriate authority regarding, my lord, running of brick field.
My lord, may I submit on? My lord, actually, this is the land dispute without.
Take the microphone, please.
My lord, this is the purely land dispute, my lord, unpartitioned land. Various members in the owner of that plot of land, my lord. My lord, they have filed a suit before the junior division, Holdia, suit for, my lord, declaration and permanent injunction. My lord, this is the copy.
In respect of the same plot?
Same plot, my lord, same plot. My lord, kindly see the.
Against that person, my lord, unauthorized.
My lord, kindly see. My lord, respondent petitioner Swapon Kumar Das.
Yes.
My lord, 9. Here, petitioner Swapon Kumar Das. My lord, kindly see the. Swapon Kumar Das, my lord, in the plaint, my lord, 9.
All of them are.
Yes, my lord, there are Bikash Patro, Bimolendu Patro. My lord, actual unpartitioned land. Some persons has already been give the lease, my lord. Others person claiming without partition of land that was not materialized.
No,
And they
no,
have
my
filed, my lord, they have filed that suit.
No, no,
before
my,
the
my lord, suit was
Junior
just
division
filed.
Holdia Court.
Some patients.
And that was
Yes,
pending.
Yes. My lord,
Still that was pending, my lord.
there was interim order for not to change and nature and.
I'll give a date in December in this case.
My lord, kind.
My lord, this is the consent of operation of the
provisions
brick
of
field,
ours.
my lord.
You are the defendants in the suit?
Yes, my lord.
Prashant Pal.
Yes.
Defendant number?
This is the only one copy, I think. My lord, Prashant. Rinku Pal, Prashant Pal, my lord.
Yes, all of them are defendants.
Yes.
This is a partition suit. Declaration and injunction.
Yes, my lord.
Yes.
And that was still pending and they have contested.
The same plots. yes.
Same plot, my lord.
Yes, what, how do you respond?
My
to
lord,
this?
who are they? How they got the property?
That is,
My lord, trespasser, my lord.
that will be decided by the civil.
No,
court, sir, not by this
no,
one.
no. What is my case? My case is unauthorized, my lord, change of nature and character of the land. That's why we prayed before the court below, civil court, not to change the nature and character of the land. Court passed the order. Kindly see the page 25. What is the order? That ad interim injunction prayer of plaintiff under order 39 rule 1 and 2 CP is considered and allowed without any order as to court. Both parties of the suit are directed to maintain status quo with regard to the nature and character over the court scheduled property of the plaintiff till 4/11/2009. Thereafter, the said order has been extended, but the authority, my lord, claiming the obtained lease or co-sharer, my lord, then he converted the land, my lord, from agricultural land to brick field.
That is pending before the.
Yes.
No, no, the separate issue, my lord, yes, if I withdraw that case, my lord, what happened? The statutory provision is there. My lord, change of nature and character, violation of the 4C of the West Bengal Land Reforms Act, criminal offense under section 4D. My lord, there are a specific.
The writ court cannot deal with it.
Writ court has the power, how the violation of the minor and mineral rules, a brick field is running. My lord, without quarry permit, without, that should be.
My lord, this is the permit, my
taken.
lord, actual, my learned friend submitting.
Who permit? Or it is permit?
My lord,
This
this
is
is the-
permit.
this
Can
is
you
the
supply
permit.
me a copy? It is permit. My lord, the authority will decide. If the authority decides the matter,
Until
I
or
have nothing
unless
to say.
His land was not determined.
How?
He is claiming that the entire land is
Agricultural land.
in favor of him, my lord.
Over a agricultural land,
Civil suit
a
is still
brick
pending.
field is running. Green branch,
Civil
my
suit
lord,
is
High
still
Court, time to
pending, my
time,
lord.
my lord,
The
issue
declaratory suit is pending. It has to be
declaration.
decided in your favor.
My lord, they are the trespasser forcibly.
That is determined by the.
Nature and character of the land.
Reiterate your submission.
My
sir,
lord,
that
I-
is not
if
pending.
Determined by the civil
my lord, violation of the.
The civil, this would be civil in nature. madam. The suit is pending and there is an interim order. If any order is violated.
You say it is your land. That has to be decided by the civil court.
My lord, only one point. The environmental policy would be violated.
That
There
is
is
another
no
thing, my lord.
statutory
This is the
provision.
consent of
You
forest.
had no
Your
jurisdiction.
primary case is that it is done in your land.
When my lord, first stages, I filed this case
That
to
point
prevent
has
them
challenged.
not to change the nature and character of the shoot land. They changed, they violated, then another
It
issue.
has to be dismissed.
But without
I'm sorry,
quarry
sir.
permit, then what happened?
It has to be your land first, then these, the
Yes,
other.
Yes,
questions-
my record of right is here.
That was pending.
Show any papers, they
You
are
have
right.
asked for a declaration before the civil court with regard to your right, title and
Yes,
interest in respect of the property.
This is not that case. My lord, record of right
That
is
was
shows.
pending. Why my
Our
lord?
right and possession. Record of right, annexure P1.
That will be decided by the civil court, sir.
Yes.
Civil court will decide, they restrain them. They
But
violated.
first prayer is for declaration of your right, title and interest before the civil court.
Yes, my lord.
Unless your right is declared, you cannot file this writ
My
petition.
lord, statutory provisions,
withdraw or
violation
have
of
to dismiss
statutory
Will
provision
you
could
withdraw
not be,
or I have to dismiss
my
on this
lord,
file?
violation of the statutory provision could not be decided
Sorry,
by
it
the
has to be
civil court.
dismissed. I'm sorry, it has to be dismissed. I can give you opportunity to withdraw if you want to, or I have to dismiss. You
No,
can
no,
approach the civil court.
It is your, no, this is not the issue. Running of brick field is not the issue. I am come here to running a brick field
Your
without
own
any
land.
authority in law.
Where? In your own land?
Law means the West Bengal minor and mineral rules. First
Running
time.
of brick field in your land, in your own land?
Which
That has
land?
not been declared by the court, by the civil court as yet.
Not let third party's land, my land, any land. Suppose my land, I have permitted
Then
him.
it's a public interest litigation if it is any land.
No. If I permitted them to run a brick field, they could not be run because the violation of the statutory
No
provisions.
question of permission because your title is in question before the civil court.
Suppose my title is, they are not, but they could not be able to run a brick field.
The
without
civil
any
suit
step.
has to be decided first, sir. After that, this writ petition. My lord. The civil suit has to be decided first.
No, civil should suppose tomorrow
I'm sorry, I have dismissed it. If you withdraw,
Then-
that is fine.
Then after withdraw my case, what would be there?
You want to withdraw the civil suit?
Yes, I can, yes, obviously I can withdraw because they already converted my
What
land.
are you seeking, sir? Do you want to withdraw or I have to dismiss the suit on the writ petition on this ground itself?
No,
And
no,
the civil suit
I-
is pending.
No, your lordship may dismiss, but I not withdraw. I withdraw civil suit. I can withdraw. I withdraw.
Court cannot give you a direction. If you want some time, I can give you time or I have to dismiss.
Yes, my lord. Urgent this matter, my lord. Yes. Yes.
Heard learned counsel, affidavit of service. The heard learned counsels for the parties. It is not in dispute that a civil suit is pending between the parties. It is not in dispute that the petitioners have filed a civil suit, a suit for declaration and permanent in declaration and injunction against the private respondents and others. Declaration and permanent injunction against the private respondents and others. Claiming right, title and interest in respect of the plots involved in the present writ petition. Paragraph. Learned counsel for the petitioners seeks accommodation. The paragraph, let the matter appear under the same heading on 12th July.
পরে দিচ্ছি, হ্যাঁ। কাগজগুলো নেবে না?
Next.
Item number 16.
16, I beg to differ on behalf of the petitioner. This is a very short matter for not granting, my lord, the compensation of a land acquisition. This is my affidavit of service, my lord. My lord, the grandfather of the petitioners was the original owner of the land in question. Now, my lord, we don't have the records, my lord. After death of my grandfather,
Appearing for the Indian Oil Corporation. They are the requiring body.
no, my lord.
Then?
The state is, my lord,
So
the
who is the
answering.
Indian Oil Corporation.
Indian Oil Corporation, my lord, the state has acquired the land for Indian Oil Corporation, my lord. But the answering respondent are the states.
Who is representing the Indian Oil Corporation? Have you served?
My lord, I have served, but it was returned back.
Who is served?
I'm the competent authority and my lord GAIL is the requiring body. So yes, take the money to us.
Servant. Affidavit of service. Since service upon the fourth respondent is not complete, let the matter stand over till 12th July.
My lord, a little shorter, my lord, if your lordship may, my lord.
What is your urgency?
No, there's no urgency.
Servant.
Egress and egress.
Item number 17.
Sarkari.
Or I am for the petition.
Hi.
Sir, one service has been effected. A petitioner's father's land was acquired by the government. And that is annexed P1. And that, your lordship can see annexed P2, that some portions of land was acquired and some portions was released. That is annexed P2, page 17. And thereafter, my lord, some encroachers, they are encroached the petitioner's, the PWD land and they are constructed a room in this head plot. For a result, petitioner ingress and egress is totally hampered.
Who are the encroachers?
But I have not made a party. But entire road was encroached by the some encroachers. My lord, thereafter, my lord, I made a representative before the authority concerned. But that till date, my lord, that has not been considered. And in earlier occasion, in the same plot, same road, that is Khusiganj Sodhpur Road, on the same road, one Osim Khara was moved a petition before this honorable court. And that was moved before Honorable Justice Amrita Sinha. Your logic is the annexure P3, page page 30. Operative portion of page 31. But they give directions upon the authority concerned to remove the encroachers for their encroachment. Thereafter, the encroachers challenged the said order before the division bench. Matter was heard by Honorable Justice, Chief Justice, as the Lordship then was. And they, Honorable Chief Justice was confirmed the Justice Sinha's order. And my humble prayer before your Lordship, kindly give directions upon the authority concerned to remove the encroacher so that petitioners can use his land and in ingress and egress should not be disturbed.
The earlier writ petition was on the same issue.
Same issue, another plot, my
This is a different plot.
different.
ওটা তো অসীম খাড়া নাকি?
Awesome.
অন্য লোক নাকি?
অন্য
এটা আলাদা,
opposite side of the road.
এটা আলাদা লোক।
হ্যাঁ।
কাকে করবো বলুন তো? কতজনকে তুলুন? কাকে তুলবি?
জায়গাটাকে খালি করে দাও তো।
কেউ আপনারা থাকেন না ওখানে?
কে থাকেন?
ওটা লেখা আছে পুলিশের রিপোর্টে। আমি দেখাচ্ছি।
আরে নাই, আমি তো চাষ করি, আমার তো যেতে
Yes, Mr. Kuchai.
My lord, I have got one report from the police authority, but not from the, my lord, the concerned authority. Police authority has been made an inquiry, and also, my lord, has submitted report. My lord, kindly go through the said report. It has been stated, my lord, petitioner is residing there. His land only is there. He resides some other
I have cultivated this land.
He resides some elsewhere.
Where is the presentation at page?
The representation is page 3, page 17.
Page 17.
18.
18. What is this?
What does the report say?
No, no, এখানে কি বলা আছে যে on the same order, all necessary steps shall be taken by the said officer strictly in accordance with law. Trying for আমি বলছি না।
The police authority has nothing to do with this. Why is
No.
the police authority giving a report? This is not
Police
necessary.
authority has nothing to do it. My lord, Amrita Sinha's order is that, my lord, there is no direct order to vacate them, to evict them. All necessary steps shall be taken in accordance to law.
Now there will be a direct order to vacate.
Your lordship, that is in another matter, that is in another aspect. Your lordship also,
Not refer to the other matter at all. This is a different issue
Yes.
altogether.
Yes.
And there will be a direct order to vacate.
Yes.
There are encroachers.
they have encroached, my lord, but according to the law, they have to follow, they have to serve the notice to them. This is another cause of action. This is another cause of action. That is another cause of action. That they are different person, we are different persons.
Dispose of the representation.
Yes.
Necessary steps.
Yes. This was the representation within necessary steps. Yes. That will serve the purpose.
Affidavit of service. ওটা ফেরত দিবেন। It is contended on behalf of the petitioner that the father of the petitioner, Onadi Charan Sarkar, since deceased, was the original owner of land in Dag numbers 1092, 1094, 1181, 1134, 1093, 923, 924, 1125 and 1135 in Moja Dehibatpur, Dehibatpur, jail number 12. The said land was acquired by the government. Today, LA case number 46 of 1975-76. And subsequently, a portion of the said land was released in favor of the predecessor in interest of the petitioner. Stop. The petitioner alleges that that there has been some encroachment on the PWD road adjoining his land, for which his egress and ingress has been totally stopped. The petitioner submitted a representation in this regard before the concerned authority on 23rd February 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the respondents that the seventh respondent, the seventh respondent be directed to consider the representation submitted by the petitioner dated such and such in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the seventh respondent to consider and dispose of the representation submitted by the petitioner dated such and such, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and in accordance with law. Within 3 months.
And also, my lord, if
within 3 months. Paragraph. In the event
yes,
encroachment as alleged is detected, the concerned authority shall take necessary steps for removal of the same
yes,
within the stipulated time frame.
Grateful.
Grateful. Item number 18.
My lord, appearing on behalf of the petitioner, my lord. This is my affidavit of service
Number 7 to 11.
affected upon all, my lord. My lord, the private respondent number 7.
Who is appearing for the private respondent?
I'm
You are appearing.
My lord, private respondent number 7 to 11 by encroaching the public land, especially the West Bengal irrigation and INW's land, my lord. They constructed the illegal construction, my lord. I given representation to the concerned authority, including the district magistrate of Purba Medinipur, and page 24, my lord. And previously, one writ petition was preferred against the PWD. After demarcation of the land, the PWD authority find out that this land belongs to the INW. That is Irrigation and Waterways Department. That is why this writ petition is preferred, my lord. Page 24. And the report, yes, this is the 62 Act. Yes, my lord. SDO is the authority, my lord.
Subdivision and land development.
Respondent number 3.
Anything to add?
My lord, two things which I want to submit before your lordship. First, he himself, my lord, yes, occupies this land and handed over it.
This is
to
the
us.
another issue, my
Kindly
lord.
see, my lord, the agreement.
This is the another issue.
Have you approached the authority?
Lordship,
Any
first thing
complaint
is
filed by
he
you?
himself, my lord, acquired these lands. He himself, my lord, occupies this land.
Submission before the concerned authority?
Lordship, and second thing is a case under, my lord, public premises unauthorized occupants act.
Yes.
He wants that we should be removed and he want to use this land. Use is also an unauthorized occupier
They
under
sub-
this act.
They will submit before the appropriate authority, my lord.
Submission. Oh, you have not come up with a writ petition. So make
Fine.
this submission before the authority, you'll be heard. Mr. Dev?
Yes, ma'am. But only one thing, my lord, under public premises unauthorized occupants act, he cannot be allowed to use it. It is not a road.
I am not going into merits at the
Lordship,
moment.
lordship.
Let the authority decide. If he is an encroacher, he'll all necessary steps will be taken against him also.
Lordship.
Affidavit of service. The petitioner complains that the private respondents have made unauthorized construction by encroaching upon government land adjoining his property, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation in this regard before the concerned authority on 3rd April 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the private respondents that the petitioner himself is an unauthorized occupant of the plot in question and seeks to evict the private respondents therefrom in order to use the plot for himself. Paragraph. Learned counsel for the state respondents submits that the third respondent is
Third respondent, my lord.
directed to consider the representation submitted by the petitioner dated such and such in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 2 months. Within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Paragraph. The private respondents are at liberty to ventilate their grievance as expressed before this court, before the concerned authority at the time of hearing. Disposed of which paragraph? Last are at liberty with the paragraph 4. Next.
Item number 19. Item number 19, I beg to appear on behalf of the petitioner.
I beg to appear on behalf of the state.
My lord, affidavit of service, there is no private respondent, but my lord, I have alleged the unauthorized construction on the government area, my lord, adjacent to my land. Now, my lord, I will not be seeking any prayer, my lord, for prejudicial to the interest of anybody. Right now, my lord, I have made an notice for demand justice to my learned advocate, my lord. The authority needs to take a call. If they find that,
Serve the panchayat? You have
yes,
visited
yes,
the panchayat?
yes.
Where is your service upon the
My
consent?
lord, page 7, Lordship will kindly find, my lord, affidavit of service, page 7.
Right, yes, very good.
My lord, as on date, my lord, I will be seeking nothing else. Only, my lord, if the authority concerned finds that this has been encroachment on the government area, because that, my lord, obstruct the ingress and egress. Now, Lordship will appreciate, my lord, probably I cannot initiate an eviction proceeding, my lord, from the government area. The government has, my lord, special procedure for that. They will have to initiate the proceeding under those acts. If your Lordship, my lord, kindly directs the concerned authority, my lord, to consider and dispose of. Or if your Lordship so pleases, my lord, we can approach the concerned authority with a fresh representation, wherein, my lord, the authorities will.
You have already submitted a representation.
Yes, I have, my lord, made a demand for justice.
Representation. This is the
Demand for
the
justice.
allegation is that the road is the classification of the road is knowingly belong to the PWD department. But no representation has been given to the PWD department.
So why don't you submit a representation before the
He
PW?
will, my lord, liberty may be
but
given to make a proper representation to the appropriate authority, and that will be considered.
No, my lord, may I, my lord, make one submission, my lord. Generally, my lord, knowingly, if your Lordship, my lord, appreciates in knowingly, my lord, certain names are always recorded. Now, my lord, what happens is, my lord, adjacent to the knowingly, my lord, there exists a road. That, my lord, may be to the belonging to the panchayat or to the PWD. That we couldn't ascertain. Now, my lord, that's why we
Cannot
made
be. Knowingly, always it is government land and it is the PWD.
the question of obstructing arrows adjacent to knowingly from where, my lord, my ingress and egress takes place. Now, my lord, both have been clubbed together. If your Lordship so pleases, my lord, here and now, my lord, we can make PWD a party, and, my lord, both of them, my lord, take a call on this issue.
I think the assistant engineer is.
Assistant engineer, PWD roads.
PWD roads.
PWD roads.
PWD roads is a
Mal.
necessary party.
My lord, if your Lordship kindly, my lord, directs me, my lord, I will add him as a
And the
party.
encroachment is on the non-Jodi or the part?
My lord, both. Because, my lord, what they have done is they have constructed
The
a
allegation
complete
is
oil.
that, my lord, the private respondent has constructed a shop room on the Noyanjul. This is the allegation. And, my lord, that person is also necessary party.
My lord, as on date, I am not paying anything prejudicial to his
That
interest.
may be, but the allegation is against
Yes.
that.
Definitely prejudice the person who is.
No, my lord,
engaging.
he will get an opportunity of hearing if he has
will get an
encroached.
Absolutely.
As on date, before your Lordship, I am not paying anything prejudicial to his interest. So that's why, my lord, whether he has made a construction, my lord, generally it happens, my lord, private respondent comes before your Lordship and says that, my lord, I am not involved, somebody else is involved. So, my lord, the authority concerned can take a call on this.
File a comprehensive representation before the concerned authority. Let the assistant engineer be added as a party.
My lord.
Let it be disposed of
My lord.
upon hearing all the interested persons.
My lord.
Affidavit of service. On prayer of the petitioner, liberty is granted to implead the assistant engineer PW within bracket roads department. The area is South 24 Parganas.
My lord, South 24.
South 24 Parganas as respondent number 9 in the writ petition. Paragraph, the cause title of the writ petition be amended accordingly. Paragraph, the petitioner complains unauthorized construction made by certain encroachers on the Noyanjoli as well as PWD road adjoining his property, comma, thereby obstructing his egress and ingress completely. The petitioner seeks to submit a comprehensive representation in this regard before the concerned authority, requesting removal of such encroachment and prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the 9th respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation before the 9th respondent within 7 days.
My lord.
Within 7 days from date. Stop. The 9th respondent is directed to consider and dispose of the representation within 3 months of receipt thereof, upon affording reasonable opportunity of hearing to all the affected persons, including the petitioner, comma, in accordance with law.
It's duly get
Disposed of.
Item number 20.
Item number 20, Lordship, Mrs. Joydeep Banerjee is appearing for the state. No instructions are coming.
Only for demarcation. That's it.
Come back. Learned counsel for the affidavit of service. Learned counsel for the respondents. Who is appearing for the Union of India?
Union of India. We have sub this.
Sir,
Yes, yes. May I check it up, my lord? I have handed over a copy from my land advocate record, my lord. May I check it up? BSNL is the.
I do not find Union of India service. Please find it. Is there?
Yes.
Affidavit of service, paragraph, learned counsel for.
Because Union of India will be served to the law and Ministry of Law and Justice. That's it.
Learned counsel for the state respondents seeks to instructions in this matter. Paragraph, let the matter appear.
I want the acquired portion be demarcated from my land. That is the only prayer.
Short issue, 23rd June.
As your lordship, please.
23rd June. Item number 21.
Madam, for the petitioner, my lord. My lord, this is a property at Salt Lake. Now, my lord, lordship knows in this.
The respondents.
My lord, I have filed an application, my lord, for addition of party.
Have you served?
Yes, my lord, I have got copy.
Where is the application, Shantanu? Can as well.
I won't do it.
Copy there. The additional party. Yeah.
Sir, আপনি আছেন জানতাম না দিয়ে দিচ্ছি
What is this?
Appearing for the state, Mr. Dev. Have you received a copy of the application?
My lord, I'll just serve him, my lord. I'll just immediately give. I'll immediately give.
I do not, it's not on in the file also.
Marked in the list, my lord. In the list.
It's there in the list, my lord. I may hand over my copy, let it be written in the record, my lord.
Let me just.
Hearing a participate করুক, my lord. আমার দরকার
Please
নেই।
give me a copy. Let me read.
Yes, yes. Because addition, I'm not opposing. Let him, my lord, get an opportunity of hearing before the authority. I have nothing to say. He's my brother only.
It's there.
Oh.
Thank you.
Sir, what happened, my
So
lord?
can is allowed on consent?
ওখানে গিয়ে যা এ করবে।
Yes, what is the matter about?
My lord, kindly, this is, my lord, page 15. This is a residential area. My lord, we have, my lord, given, my lord, on rent, my lord.
One submission, my lord. Once the can is allowed, my lord, formally, my lord, I should be given a copy of the written. Otherwise, my lord, prior to that, my lord, I will be, my lord, able to, my lord, make my.
He will only make his submission before the authority. At this stage, in this writ petition, only a consideration order can be passed, nothing else.
Whether, my lord, at all, my lord.
He has to go through the writ petition.
Very well.
Serve is a copy in course of this day. I'll give you a date.
পড়ে নে।
Short. I'll give you short. Affidavit of service.
Yes, my lord, he will be given an opportunity of hearing. My lord, I concede to that also. At this stage, my lord, my prayer is also to dispose of my
Not
representation.
embarrassing. Come back. I'll give you a short date. Can one of 20.
তাই তো হবে।
The applicant / intervener seeks to be added as a respondent in the writ petition. Paragraph, the application is allowed on consent. The applicant be added as respondent number 4 in the writ petition. The cause title of the writ petition be amended accordingly. Can such and such is disposed of. WPA the order to affidavit of service. On prayer of the added respondent, the matter is adjourned. Let the matter appear under the same heading on 22nd June.
Yes.
He wants to go through the petition.
My lord, kindly takes it up on 22nd, my lord, dispose it of.
He has just received a copy,
Only
almost
once.
not received.
Yet to, my lord.
22nd June, a short date.
The department be directed to amend the cost titles.
Item number 22.
Cost title amended. Department continue.
My lord, I am for the petition. My lord, I am for.
Served.
Yes, ma'am.
Gas Authority. My lord, I am appearing for Union of India. Union of India, what about the Gas Authority?
My lord, I am for gas authority.
You're appearing? Very good. Yes.
My lord, the petitioners are the farmer.
The microphone.
My lord, the petitioners are the farmer and they are opposing own sees possess the separate plot of lands in the Babla Muja of Bardhaman. My lord. My lord, that plot has been affected due to the such notification which has been issued by the authorities for the purpose of acquiring the plot of lands for the purpose of installation of pipeline. My lord. My lord, the authorities, the respondent authorities issued notification and subsequently sub notice, thereby assessing the amount also, my lord. My lord, the amount which has been fixed by the respondent authorities is amounting to rupees 53 to 60,000, my lord, per decimal. But the deed which has been recently registered showing that the per decimal of the plot of lands in the said area is amounting to rupees 4 lakhs which has been registered in the year 2022 and 2023 3 lakhs 5,000, my lord. So my lord, in accordance with section 26 of the Right to Fair Compensation Act, my lord, the amount is to be fixed on the basis of the deed which has been registered recently, my lord.
Yes, let us hear the.
My lord, upon being aggrieved by such whimsical decision of the authorities, the petitioners jointly made separate representatives to the authorities, which is still pending before the district magistrate Bardhaman and the special officer also, my lord.
Where are your presentations?
My lord, page 108, my lord. Annexure P6, my lord.
This is a joint representation.
Lordship. And another is, my lord, page 111, my lord, P7.
You want both to be considered?
Lordship.
Considered?
Lordship. And my lord, during upon filing of this writ petition, the authorities are trying to possess this land forcibly, and even the authority has lodged a written complaint against the farmer.
You cannot obstruct a public project, sir. Compensation, you can ask for enhancement, that will be considered. But can you stop a public project? You cannot. Let that continue. Yes.
Land acquired under the provision of 1962 Act. But there is a provision that dispute is with regard to the compensation or quantum of compensation. That has to be decided by the district judge.
Give me the act.
Section 10. Section under the 11(5) of the Act of 1962, the Act is not.
You have a copy of the act with you, the statute.
Section 10. Section 10 subsection.
There is a specific provision under 10(2) of that.
What? 19?
The Petroleum and Minerals Pipeline Act 1962. Section 10(2), have you gone through it? There's a specific provision for this. You want to go through that?
My lord, I have.
You have a copy?
But my lord, the authority never heard the farmers, my lord. And if they have any objection, that has not been at all considered, my lord. Upon considering this, the objection, if raised by the farmer, then the, my lord, the compensation is to be fixed. But the authority whimsically fixed the amount and they have served the notice upon the farmer, my lord.
You have received the compensation?
No, my lord. Till date, I have not received, my lord. Only the notice has been served. But that notice has been served without hearing the farmer, my lord.
You are agreed with the compensation, that is your prayer for enhancement of compensation.
Lordship.
So the district judge is the authority, not the
But-
DM.
But my lord, at least the opportunity is to be given to the farmer to hearing, my lord.
It will be given to you by the district judge. Please see the section, the provision, isn't it? This is a self-contained act. So the opportunity will be given to you by the district judge.
Lordship.
He will assess compensation upon hearing you.
Lordship.
So will you withdraw and approach the appropriate forum?
The amount of compensation.
Yes?
Yes, Lordship.
So you'll approach the appropriate forum. I'll grant you liberty to withdraw.
Lordship.
Affidavit of service. The petitioners are aggrieved by the compensation assessed by the authority for acquisition of their land under the Petroleum and Minerals Pipeline Act 1962. Stop. The petitioners seek to withdraw the writ petition and approach the appropriate forum for redressal of their grievance under section 10(2) of the Act. Paragraph in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioners to approach the appropriate forum for redressal of their grievance. Paragraph, there shall however be no order as to cause as a certified website copy.
Well, may I take that?
No, dismiss for non. In earlier matter, in addition of party, your lordship has been kindly direct the department to amend the cost. If your lordship kindly allow me to add here and now, my lord, that's why, my lord, I'm-
Yes, next.
Item number 23. My lord.
Yes.
No, this matter was earlier considered by your lordship. Kindly come to your lordship's order as 157.
Only the state respondents?
Date of the order 4th of April 2023.
Have you served the private respondents?
Private respondents, yes, yes, man. Everybody is. এখানেই করে দেবে তো? এটা নট ওয়েস্ট এদের কার পক্ষ করেছে না প্রাইভেট লোকগুলো ওই জিএনপি কি করবে কি করেছো
11 has not been served.
only 11 I sent for service might be one of them as this is the
You are
virus
supposed to check, sir, not the court.
virus of the rule and policy is under challenge
He must,
Come back.
and he must give the copy to the Advocate General, my lord. The virus was
Yes,
challenged,
if virus is challenged, you serve the Advocate General.
serve the Advocate General.
Since service upon all the respondents is not complete, affidavit of service.
That's it.
Affidavit of service, since service upon all the respondents is not complete, let the matter stand over till 12th July.
Item number 24.
Lord, I'm appearing, my lord, for the writ petitioner. My lord, I have, my lord, I'll tell my lord why, my lord, because we have not been able to serve, my lord. I took leave, my lord, because of the urgency of the matter. I'll just take 2 minutes, my lord, to tell my lord the urgency. Then, my lord, whatever, my lord.
This is a tea estate in North Bengal.
Yes, my lord.
The Jalpaiguri Circuit Bench is in session.
My lord, but we are, my lord, complaining of, my lord, issues with regard to, my lord, I'll just give just one in 3 sentences, my lord. May I just try and.
The circuit bench is in session. So
My lord, perhaps, my lord, the centralized, my lord, jurisdiction, my lord, is what, my lord, is happening.
not when the circuit bench is in session.
No, my lord, the issue, my lord, what we are complaining of is, my lord, on the question of, my lord, I have a tea estate. It's on a lease, my lord, from the government to me, my lord, for 30 years. That's, my lord, till 2041. My lord, what they have done under the, my lord, garb of, my lord, some scheme called, my lord, Rasta Sri and Potho Sri, my lord, which is, my lord, administered, my lord, from here. My lord, they are, my lord, gone inside my garden and, my lord, start building roads inside my garden. This is, my lord, the objection, my lord, which I have. Construction has started. I was not aware. My lord, I only came to know, my lord, in April. I kept writing letter, my lord, in May. On 29 May, my lord, all of a sudden, my lord, they broke open, my lord, my gates and, my lord, got in and, my lord, started, my lord, construction.
The
My lord,
circuit bench will deal with it. It is in session still. I cannot deal with this matter.
my lord, we have not, my lord, this is, my lord, not, my lord, though, my lord, the tea estate is there, but, my lord, we have not, my lord, it's not, my lord, a Jalpaiguri, perhaps, my lord, matter because,
Because it's Alipurduar.
sorry, my
All
lord.
the authorities are from Alipurduar.
My lord, the first respondent, my lord, is here because we are not, my lord, my lord, this scheme.
It's the Ministry of Land and Land Reforms. We ought to be here, but the others are all from Alipurduar.
My lord, because we, my lord, only came here, I'll tell my lord, quite, my lord, candidly, my lord, because this scheme, my lord, they say it's a scheme, if I may show. So the scheme, my lord, is something, my lord, which is, my lord, being monitored from here. We are not, what is the,
Have to go before the circuit bench. I'll send the file immediately.
my lord, the urgency is, my lord, that the construction work, my lord, is going on. That's, my lord, the difficulty.
Try and send it. You can send your documents through mail, I think. I'll send it to you here and now. Shantanu? Circuit bench will-
My lord,
Alipurduar circuit bench, yeah? Circuit bench, Alipurduar.
jurisdiction is over, কি করে হবে?
Alipurduar matter, means it-
চলে যাও।
তখন তার file দেখি। I'll send it here and now. It immediately পাঠানো হবে।
My lord, may I, my lord, try and persuade my lord to, my lord, at least, my lord, grant us, my lord, some kind of interim protection. Because, my lord, the construction,
I cannot. That's
I
the
know,
rule
but
of
I,
Chief Justice, I cannot.
yes. I'm, my lord, fully, my lord. I'm grateful, my lord. We'll just, my lord, try to take steps immediately.
The matter pertains to the circuit bench at Jalpaiguri. Let the matter be placed before the honorable circuit bench. Honorable circuit bench at Jalpaiguri.
I'm grateful.
At the earliest.
I'm grateful.
Before the honorable circuit bench at Jalpaiguri. At the earliest.
District Howrah লেখা আছে।
District Howrah at the
District Howrah.
It has nothing to do with
Oh, first respondent, my lord, because, my lord, the first respondent. I'm not really grateful.
District থেকে petitioner.
Yes, next one.
Item 25. May it please the lordship, my lord, this is my writ petition, my lord, assailing an action on the part of the Ministry of
Service.
My lord, service we have affected by email. My lord, may I file the affidavit of service to that effect? The office of the, my lord,
Savvy till date.
but
Email
I would be
service.
pressing for, my lord, rule 26 of the, my lord, appellate side rules, my lord, where without service also your lordship has the jurisdiction and the power to, my lord, take in, if your lordship is satisfied of the urgency. I need to satisfy that.
Why don't you serve and come back?
My lord, I'm led by-
briefed
Very
on
short, you can serve and come back.
Only apprehension is, my lord, they have imposed a penalty
And we are apprehending that they may invoke our bank guarantee. But to that extent, kindly protect us till the return of.
On Monday?
Well, Monday, I have some difficulty. Could it be Tuesday? But kindly make this observation that.
The Union of India, Ministry of Environment, you can serve in a day. So why don't you serve, make a hand service and come back? Tuesday?
They refused. They refused.
If they refuse, if that's endorsed, I'll take it up.
Well, what they have done is I am submitting upon instructions. What they yesterday they have refused. In the morning we went to serve. Well, they refused.
Where is the endorsement?
Well, they have refused to take even. There is no endorsement.
My lord, I believe in the affidavit of service, my lord. Yesterday's refusal has been stated.
Where is it stated?
Paragraph 3, my lord. I'm sorry, without the
You emailed it after refusal. You have
Yes,
mailed
yes.
it after refusal.
Yes, yes. The intentions, my lord, that is what we are concerned about.
Please, let me hear.
Yes, sir. Yes.
This pertains to, my lord, allotment of a coal block. Now, my lord, if your lordships remembers, my lord, initially, my lord, coal blocks, my lord, were, my lord, allotted by the central government to various authorities, private parties, public sector undertaking. Thereafter, my lord, in a PIL, the Honorable Supreme Court found that the screening committee which had screened and allotted it did not do it properly. Therefore, my lord, all coal blocks allocation were cancelled and where the central government took over the coal blocks once again. Now, in some of the coal blocks, there were certain activities which were going on. This is one of those coal blocks, Gaurandi coal block. Thereafter, my lord, again, my lord, these were auctioned. My lord, my client, that is the petitioner over here, is presently being allocated with this coal block. Now, my lord, for the purpose of execution of the work, my lord, there are certain events which is to take place from time to time. Now, my lord, if your lordship may kindly have a look to, my lord, page.
The petitioner is the Mineral Development Corporation.
Yes, yes. That is it is the allotting. Now, wholly owned by the state government. Now, my lord, there are certain efficiency parameters, my lord, which have been provided in the allocation agreement itself. Please have a look to one page, that is page number 104, where your lordship would find, my lord, the milestones that are to be achieved one after the other.
Yes.
And, my lord, the failure against each of the milestone may result in certain penalty. Kindly take, my lord, the second column, that is the milestone column. And on the extreme right-hand side, your lordship will find weightage for calculating deduction of performance security in case of failure stroke delay in achieving the milestone. Well, we have given the performance security, there is no dispute on that. Now, my lord, we receive series of, my lord, show cause notices. The first show cause notice is in connection with serial number 7. My lord, the show cause notice is at page 132. Kindly note the page number. Then, my lord, serial number 8 is forest clearance application. My lord, we have done that within time. This is serial number 8. Then comes serial number 9, which is forest clearance. My lord, they issue a second show cause notice in respect of serial number 9. Now, please have a look to this show cause notice at page 134. Now, please keep 104 open.
Yes.
At 134, well, this is the second show cause notice in the series. Subject is show cause notice for non-compliance of efficiency parameter of allotment agreement in respect of so-and-so colliery. Please take serial paragraph number 2. However, it has been noticed that as on date, the following milestones in respect of Gaurandi ABC coal mine have not been received till date as per the stipulated timeline. Milestone, forest clearance, due date is 29/6/2018. And number 2 is environment clearance, that is 29/6/2018. And Milord, the last column says that weightage for apportion of security deposit is 5%, 5%, 10%. Now, Milord, we had applied within time. Kindly take me to the next page. We are being asked to show cause. Now, Milord, we show cause, Milord, at page 36. 136, I'm sorry. Please take serial number A. Milestone is forest clearance application. Due date is 29/8/2017. Achievement date is 12/7/2017, which means that we have applied within time. Status achieved in time. Then the second one is forest clearance. Due date is 29/6/2018. And at the status, we have said that not yet received, because forest clearance is to be given by the Ministry of Environment and Forest and Climatic something. Then, Milord, thereafter, we say whatever the actions that we have taken, Milord, date-wise. There's a list of dates below that. Milord, whatever we have done, we have said. Now, please turn the page. This is the second one, that is the environment clearance part. In the middle of that page, your Lordship finds a chart. In the chart, due date for application was 29/8. We have applied by 28/8, achieved in time. And the clearance part we had applied, but not yet achieved. But then we have given the list of dates as to what has happened in respect of that. Now, Milord, based on, Milord, my second reply to the second show cause notice, a scrutiny committee meeting was held on 13th of December 2019 at page 139. It involves, Milord, a lot of coal blocks. Milord, our concerned one is at page 154. Please take 154.
Yes.
At the top, your Lordship finds Godandi ABC. Please take serial number 2 and serial number 3. But in both cases, on the right-hand side column, on the under, Milord, observation of the committee, please take, Milord, the next page at page 155 instead of taking your Lordship in its entirety. Fourth line from the top at page 155.
Yes.
In the next meeting, the facts and delay in obtaining of the clearance on the part of the allotee as provided by the allotee is to be put up again. So they don't decide it, they defer it. Similarly, in respect of delay in EC, please come to, Milord, page 156 at the right-hand side column at the top. In the next meeting, the facts and delay in etc. will be considered. So, Milord, it is deferred till the next meeting. Now, Milord, in the next meeting, which happens on, Milord, October 2020, please take, Milord, page 166. Relevant portion is page 185. They sought to, Milord, seek clarification from the appropriate authority. Please take, Milord, page 185. Gorandi Koliali. Please take, Milord, page 186, right-hand side column, second paragraph. Or may I read from the first one? The committee considered the submissions made by the allotee and directed the office of the nominated authority to seek clarification from the relevant government departments of West Bengal to determine whether the delay is beyond the control of the allotee or otherwise. Matter put up next. But the same thing your Lordship finds at page 187 for environment clearance. Milord, the scrutiny committee, Milord, calls for clarifications from the appropriate department. Now, Milord, Government of West Bengal gives its clarification at page 223, I'm sorry. saying that we are not at fault. Well, unfortunately, this is the entire letter is not with us. Please take the second paragraph. It is evident that both for EC and FC, WBMDTCL has submitted applications on time, but till date, both are pending for approval at different levels. For FC, WBMDTCL has suffered badly due to the fact that as per notification dated so-and-so, compensatory afforestation patches less than 5 hectares accepted by the forest department have not been considered. But the rest I don't trouble for the present. Therefore, they say that we had applied within time. The government gives its reply. Then, my lord, the third show cause notice comes at page 224. Where the third is, my lord, please come back to page 104, my lord. The sequence your lordship will get, my lord. The second show cause notice was in respect of serial number 8 and 10. Now the third one is, I'm sorry, 9 and 11, where the third show cause notice in respect of serial number 13, 14, 15 and 16. Please compare, my lord, 13, 14, 15, 16 with at page 104 with page 224.
Yes.
Well, this is the third show cause notice in the series. Millard, we give our reply, Millard, at the next page. That is page 226. Millard, we give a reply. Now kindly take the 13th meeting. This is very important for me at page 274. Where it starts at 244. The one with which I am concerned is at page 274. In fact, I'm so sorry, Murad, it is 271. It starts at 271. Miller, please take 272, the right-hand side column, second paragraph. But this is very important for me. As such, the committee recommends that the delay cannot be attributed to the allottee, and the relaxation may be provided to them by waiving the appropriation of 5% bank guarantee. But this is in respect of forest. Now, I'm sorry. Oh, I'm so sorry. But this is in respect of the first show cause notice. I stand correct. All the clearance are interdependent. These two parts are very, very important for my subsequent submissions. First is they come to the conclusion that it is beyond my control. And second, they say that all the clearances are interdependent. Now, kindly take me to the next paragraph in bold. In view of the same, the committee recommends that once EC and FC are obtained by the allottee, then along with the reasons for delay may be put up by the office of the nominated authority before the scrutiny committee for final decision. Therefore, everything is being kept on hold till such time EC and FC are given. Milord, kindly note, Milord, as of today, Milord, ECFC has not come. But after this conscious decision, what is happening now, I draw your lordship's notice. Page 274 is, Milord, very important for my case. Then comes, Milord, the fourth show cause notice. which is at page 301. Kindly take me to the second volume. Keeping page 104 open, kindly now consider 301. This is the fourth show cause notice. What is the ground today? The ground is that the mine is not operational till now.
Production.
But please take me at the third paragraph. However, it has been noticed that the mine has not been operationalized till date, and as per efficiency parameter, the schedule of production reaching peak rated capacity should be as per mine plan. Accordingly, production for the year so and so has not been met as per the approved mining plan. Well, with respect, this is ridiculous. They say that there is no ECFC. I am not liable for that. They keep things pending till such time the FC and EC is achieved or issued. But they say that I have not been able to operationalize the mine. Now, I reply at 303. Your Lordship may skip it over for the present. Then comes the fifth show cause notice at page 306. Where this is serial number 17 as per page 104. Please take the second paragraph. However, it has been noticed that the mine has not been operationalized till date, and as per the efficiency parameter, the schedule of production reaching peak rated capacity should be as per the mine plan. Accordingly, production for the year 21-22 has not been achieved as per the approved mining plan, the details of which are given below. For the year 2021-22, the target was 1.5, I think it should be lakh, million ton, na? The metric ton. 1.5 metric ton hobe na. Whatever. Million ton. Acha. 1.5 million ton, Milord. They say the actual production is so and so. This is the fifth show cause notice I received. Milord, I give my reply to it at page 307. Then what happens is, Milord, contrary to page 274, Milord, the nominated authority, Milord, arranges a meeting. And Milord, the minutes of the meeting, your Lordship will find at page 312. I'm sorry, 200 and, yes, 212. 312, sir. Milord, please take, Milord, Gaurandi ABC, serial number 1, the last 4 lines. The nominated authority stated that WBMDCL is not making any serious efforts for starting the mine, and on one or another pretext, they are unnecessarily delaying the project as it was allotted in the year 2016. No substantial progress is visible in the last 7 years. He advised Office of the NA to issue show cause notices for delay and put it up for consideration before the scrutiny committee. Then when the minutes of the meeting comes to me at page 313, please take, which is now before the scrutiny committee, please comes to page 319. I'm sorry, 380. Milord, 274, they say 3 things. I am not guilty. Number 2, all the parameters are interdependent. You cannot skip over one. And number 3 is after the FC and EC is received, then put it up for consideration. Therefore, everything should be stalled till such time the clearances are received. Now, see, Milord, what this same scrutiny committee in the 19th meeting does. But the first one is Gaurandi, where there is a chart at that page. First is forest clearance. In the middle of that page, right hand side column, The allotee informed that they have identified 30 patches of land having area less than 5 hectares for so-and-so. However, MO so-and-so with a notification so-and-so stated that the area was less than 5 hectares, which will not be suitable. Due to this, they had to rearrange for the land. Accordingly, they rearranged land, but MOEF was again returned the proposal with queries that identify CA's land fall within the existing forest area. MOEF did not find it suitable for the CA purpose, even though that patch of land was found suitable by the state government. Once again, they arranged new CA land and proposal was sent to the MOEF. The FC proposal was again considered in so-and-so meeting, but deferred with 5 observations mainly related to discrepancy in the mine plan approved by so-and-so to conduct site visit of FAC, etc. And insofar as environment clearance, they deliberate that allotee informed that in the 3rd meeting of so-and-so, it was pointed out that pointed out by EAC that the equipment configuration and OB schedule is not optimum in existing mining plan, and accordingly they suggested for revision of mining plan. Further, allotee stated that initially CCO considered it minor changes in the mining plan, but later, before approval, they called it major change. Allotee stated that the revised mining plan has been submitted in so-and-so. Now the observation at the bottom. Mining plan is a tedious and a long process. I'll address your lordship later on appropriately. Now please say have a look at what is the observation. Committee agreed with the view of the Ministry of Coal for reconsideration of pending show cause notices of this mine. It was observed that the proposal for the EC and FC was deferred many times by the ministry, which shows that the application was not complete and the allotee was not able to justify their proposals before so-and-so. It is the job of the allotee to submit application in completeness and foresee the likely observations that may be issued by so-and-so and comply with the such and such raised by so-and-so. In case the MOEF is not satisfied with the ECFC proposal, they are within their right to defer the proposal. Then the next sentence is important. It is the responsibility of the allotee to comply with the observations of so-and-so. Committee observed lack of sincerity and foresightedness on the part of allotee. There may be some procedural delays, but it is mainly the responsibility of the allotee to get the statutory clearances for starting mining. The committee concludes that the allotee is mainly responsible for failure in achievement of the milestone for which show cause notices were issued and which were considered in the meeting. The committee recommended for imposition of penalty as per the provisions of the allotment agreement for failure of achievement of milestone. Now, this is where my urgency lies. Now, what will they do? Now, please have a look to the relevant clauses. Yes. Well, one more letter, I missed out, which is at page 364. But this is 11th May, that is after the 19th meeting. Where we make a representation at page 617. I don't trouble you with that for the time being. Page 364, again, the ministry or the Ministry of Coal, that is the appropriate ministry, is writing to the Forest and Climate Change Department Ministry. Please take me to the second paragraph, the third last line. Or by second last line. But I don't take your lordship through the facts which I have already taken. As such, the proposal has been deferred in view of different queries, environmental deemed clearances, directions at different times. Then the next paragraph, besides the above, FAC was formed on so-and-so with direction to make a field visit and submit a report. However, neither the field visit has been made nor any report submitted till 24th March. On 24th March, so-and-so considered the proposal and reconstituted the subcommittee again with directions to make a field visit and submit a report. The field visit by the new subcommittee is currently awaited. In view of the above, it is requested that the concerned be directed to examine the matter and take necessary action as deemed fit to resolve the issue concerning the site inspection by the subcommittee, pertinent to mention here that the operationalization of the coal mine is contingent upon FC application being processed in a timeline manner. So when everybody is, my lord, at one, that these clearances are fundamental. Thereafter, everything will follow. Now, my lord, 5th June, my lord, I come to know of, my lord, the 19th committee's meeting or the resolution, which is at page 316.
316.
Yes. But I come to know why, my lord, we are troubling your lordship, my lord. So your lordship is hard pressed.
For the 19th meeting.
19th meeting was, the minutes was given to us. Meeting is of April. We have been served with it, my lord, on 5th of June 2023 at page 316. Fifth, they give us the copies of the scrutiny committee meeting minutes, and my lord, we make a representation to them on yesterday, on 7th of June, day before yesterday, which is at page 617. Your lordship need not look at it for the
Still
time.
awaiting approval of the competent authority.
I'm sorry, my lord. Yes, it's under consideration.
Approval.
Yes, yes, definitely.
Still are not under threat then.
No, why I'm under threat? Now, please have a look to the my lord, terms and conditions. But first, kindly take, my lord, page 6.1.1 at page 69 is my obligation to furnish the performance security, which I have done. Now take, my lord, 6.2.1D at page 72. Yes. It starts from page 71. 6.2 is events for appropriation of performance security. But it starts from page 71 at the bottom. I'm sorry, ma'am.
This is the allotment agreement.
Yes, this is the allotment agreement. 6.2 at the bottom of page 71, events for appropriation of performance security. 6.2.1, the performance security may be appropriated by the nominated authority upon the occurrence of any of the following events, the appropriation event to be determined by the nominated authority in its sole discretion. Now, please take D thereunder. D for Delhi, failure of the allottee to comply with the efficiency parameters as required under clause 10. Now, clause 10, my lord, will find at page 79. (10.1) The conduct of the mining operations at the coal mine shall be subject to the milestones listed in Schedule D, the efficiency parameters. This is 104 that, my lord, I had placed before my lord. That the table at page 104. Yes. Now, manner of appropriation at page 73 is 6.3. (6.3.1) Upon occurrence of an appropriation event to be determined by the nominated authority shall have the unconditional right to appropriate the performance security by providing a written notice to the allottee in the following proportion. Please come to serial number 4 at the bottom. But I hope your lordship's brief is not marked.
No, it is kind of, it's just underlined. Never mind.
4, failure of the allottee to comply with the efficiency parameters as required under clause 10. On the right hand side column, such percentage of the performance security for each failure to comply with the efficiency parameters as specified in Schedule D. Now, the percentage your lordship has found, Miller, at page 104 is, Miller, the extreme right hand side column. So for each of, Miller, for example, please have a look to, Miller, page 104 once again on this aspect. Say, for example, serial number 9, forest clearance, there is their allegation they are going to deduct, my lord,
5%.
5% in that manner, my lord, so far as these are concerned. Now, my lord, these are the facts of my case. My first contention is, my lord, the finding or the conclusion is that I am not responsible. Number one, if all these clearances are interdependent, then unless 9 and 11 at page 104 are achieved, you cannot go below that. The subsequent show cause notices from the third show cause notices are, my lord, all, my lord, in respect of events after serial number 11. My third is that, my lord, there is no change of situation since the 13th meeting to the 19th meeting to alter the previous decision. In fact, that has not been altered. Be that as it may, it has not been altered. Therefore, my lord, in my very respectful submission, my lord, this is, my lord, absolutely arbitrary and whimsical. But if required, my lord, I'll address your lordship, my lord, on the latest judgments which say that, my lord, in
June,
my lord, 5th June, 3-1, 5th
your prayer B,
316.
316.
That is the communication.
Communicates the minutes of the night.
Yes. 316. Yeah.
দিল্লি থেকে আসলে ব্যাংকে গিয়ে ইনপুট করে দেবো টাইম
And the recommendations of the scrutiny committee as referred to in this application. You're asking for a stay of those
Stay.
recommendations.
No further steps.
319.
Yes. Pursuant to page 319. My lord, is the decision which should not be, my lord, given effect to, and this was communicated to us, my lord, by 316.
The prima facie case has been, of course, made out. Let there be an interim stay.
Yes. Agreed.
And I would request you to inform the respondents once again.
Definitely.
Affidavit of service. None appears for the respondents despite service.
My lord, please also dispense with Rule 26. But I pray for this, my lord.
Certificate shows service.
Very good.
So no question of
Very
226.
good.
That's why for abundant precaution, please make a further service.
Yes, my lord, actually, my lord, Rule 26 requires me to give 48 hours notice. But, my lord, your lordships have also the power to condone it. Dispense with that. Not only that, your lordship can also allow me to move it with a short notice of, say, 12 hours, 2 hours, or ex parte also.
Since prima facie service is shown.
If my lord is satisfied, my lord, I admit that.
There will be an uproar, but we'll deal with it. It's contended on behalf of the petitioner that an allotment agreement for the petitioner and the second respondent for allotment of ABC capital my whole money on 23rd August 2016. and the petitioner was supposed to operationalize the said mine subject to compliance of scheduled efficiency parameters laid down in the agreement itself. Stop. The petitioner applied for forest clearance as well as environment clearance within the stipulated time frame, but has not received such clearance certificate till date. Stop. Several show cause notices were issued upon the petitioner. Sure. For alleged non-compliance of the efficiency parameters, which the petitioner sent replies. The 13th meeting is at page.
Milord, it's at
Let me
page,
say that you're not at fault.
Milord, 241,
312.
43.
yes.
Ours is at 271 at 274.
274 is, Milord, the part that I rely on. Beyond control and,
You're not at fault.
yes, 274, yes. Right inside.
This is the 13th meeting.
This is the 13th meeting.
In the 13th meeting held by the authority on
The 26th and 27th of February.
It's 26th and 27th November 2020.
26th/27th November 2020. It was sought by the authority as hereunder, inverted comma open comma. The state government letter dated 23rd July 2020 has been considered by the committee, which says that allotee may not be attributed for the total delay in achieving the milestone in respect of FC/PC, page 273 department, for Gorang B ABC. Stop. The committee is of view that the delay in achieving the milestones/pending clearances is not wholly dependent on the allotee, since identifying CA patches and time taken by Forest Department in giving suitability certificate after due process were beyond their control. Stop. Moreover, all the clearances are interdependent. Paragraph. In view of the same, the committee recommends that once EC and FC are obtained by the allotee, then along with the reasons for delay may be put up by the office of the nominated authority before the scrutiny for final decision. Stop, inverted comma, closed. However, it is submitted on behalf of the petitioner that despite such resolution taken in the 13th meeting, comma, the committee, comma, in its 19th meeting, the scrutiny committee, comma, in its 19th meeting held on 19th and 20th April 2023, comma, concluded that the allottee is mainly responsible for failure in achievement of milestones for which show cause notices were issued and which were considered in the meeting. Stop. The committee recommended imposition of penalty as per provision of the allotment agreement for failure in achievement of milestones. Copy of the notice was served upon the petitioner by a letter issued on 5th June 2020. Paragraph of consideration of the material on the comma, this court is of the view that this court is inclined to hold that in view of the resolution taken in the 13th meeting of the scrutiny committee has been prima facie case, and the resolution taken in the dated 19th and 20th April 2023 and communication of the same made to the petitioner on 5th June. Adjudicated in presence of the respondents. Let there be a limit. Since they are not.
May I only seek this indulgence? Please have a look to prayer G. Prayer G. If a lordship member pass an ad interim order in terms of G. Stay and G. Or if I may frame it, yes, H and G, where H your lordship has passed, and J if your lordship has.
Because they are not strictly bound by the recommendation. They can do on their own.
I'll add it. I'll add it.
For a nominated authority.
Thirty-first August, serving the meeting. Paragraph, the first and second respondents should be restrained. 1 and 2. First paragraph, the first and second respondents are restrained from appropriating the performance. Paragraph. With the same heading. 26th July. Paragraph, the petition is directed to serve notice upon the respondents intimating the adjourned date.
I'm grateful.
Ashwin.
July as well.
Item number 26.
My lord, in item number 26, my lord, one of the writ petitions is appearing, my lord. My lord recalls, my lord, this is with respect to the fact whether the Zilla Parishad has the power to, my lord, order demolition of a structure, my lord. My lord, one of the writ petitions is appearing, my lord. Our writ petition is not appearing. Kindly, my lord, these were tagged together, my lord.
দুটোই আছে But then in the list, my lord, only one, my lord, my learned friend's writ petition is appearing, my lord. Ours is not appearing.
Come back some other day.
My lord, in that event, my lord. My lord, next, my lord, if it can be on Friday week, my lord, if it so commences to lordship. And this is the second writ petition. My lord. And this is the second writ petition. My lord. May I hand over to?
It's 1688.
Yes, madam. 1688. Nahi,
WPA 1688 is not appearing in the list. Paragraph, let both the definitions appear under the same heading.
if it so commences, my lord, Friday week, my lord.
Why Friday? 28th June.
Obligation.
28th June.
28th June. Obligation.
Next.
I'm for the municipality, my lord. I find my report, my lord, Mr. Bashu.
No.
This is my secretary of correction. Mr. Bashu's clients, there is a question that municipality has enclosed their land and established a bus stand. I submitted a report, my lord. The report municipality by the resolution side, they have not met. Apart from that, there's a question on local stand or Bashu's clients. I'm not going to this question now. If you also can see my report, Bashu's main case is that municipality has made a bus stand. Our stand is not. You can come to my report, my lord, at page 161. The report of the municipality. So I'm not going to question the master client now. This is can see on page 161 my report.
Yes, page.
161 of my report. This is called.
161, yes.
Yes. But this is the resolution taken and signed by the. No significant opinion of order. Number 2 page. Municipality has not taken. Yes. And this is our but it's a question of some local standing versus clients are writ petition. I'm not going to this question. This is the only point in the writ petition is now involved. So without prejudice, the question of local standing might not only decide this point.
So no one takes responsibility of the bus stand.
Now he is saying that he is not taking the point of local standard. Entire volume of the
No, I'm not
is on
taking. I
that.
said without prejudice too. I said that then it will take time. It will take days, state come. It's a big. My lord, I have taken. I said the buses are not the no more the owners. So state also have taken the points. But the issue is very short now. Issue is this is whether municipality made a bus stand or not. Municipality stand is that they have not made.
See that we have not made. So you disown.
But it is being used at a bus stand.
That I mean.
Has state come with a report?
Yes. No, my lord, we have not filed any.
This is state also.
They file on the question of local stand.
The state has filed a report?
Yes, but
State is not aware.
Chondida is not our. State is our. Chondida is not ours.
No.
Yes.
All the file is with the junior, my lord, as because for that is.
Oh, you want to come back some other day?
Yes, my lord. Can you make it up to 18? 150 for that is pilot has come, man. Oh.
Oh, for that reason, file.
Yes, my lord. Pilot has not come. This is at a snail space, my lord. Make it after 18. 18 after 18.
After 18.
Yes.
No. It used to be taken up only when the vacation bench is, circuit bench is there.
Last week I have not
allowed to take both benefit of both the.
But then he should not go there.
I am occasional visitor. He is having both establishment there.
That's your problem.
That is my problem.
But sir, not dirty place is there. This is the main problem.
But can you pass a small order?
I'm from Shiliguri.
State bus থাকে না আমাদের কি এখানে ইনভলভ
এটাই হবে
This is
27.
At number 62.
Appearing for the first time? So you need some more time? On prayer of the petition? 1 month? Petitioner, the matter is adjourned. Let the matter appear under the same heading. On 20th July. Sorry, 21st.
Number 63.
Worship for the petitioners. Yes. Yes. Is appearing for the petitioner? Petitioner. You're appearing? Petitioner. Yes. Take the microphone, please. You wanted to place certain authorities.
Lordship, can you give me 2 minutes time, Lordship? The petitioner will come.
Order though. Right. Last question, we have completed our submission. That's
Wanted to place certain authorities with regard to.
yes, madam.
Says the same matter has been decided before a single.
I have cited that. Can you see your lordship's last order, lad? Two judgment I had cited, lad. On my iPad, so. এটা কোথায়?
Supreme Court judgment.
Yes, lad. One is of our High Court, lad. Justice Shobhusachi Bhattacharjee.
This is an appeal I found.
এই তোমার সাইটেশন গুলো কি ছিল গো?
হ্যাঁ। আহা। উপরে তো করতে জাজমেন্ট। iPad নিচে। iPad নিচে।
Justice Talukdar. Yes. Mr. Sen also wanted to bring, show some authorities to.
Yes, yes. One of the main point that I urged is that the notifications which have been challenged herein, my lord, those were already challenged in earlier writ petition. And the judgment was delivered upholding the same. Now, the coordinate bench decision was then, my lord, taken up before the division bench. Now, the division bench almost, my lord, stamped the same as valid, but only one modification was there. In any event, since it's a modification of the order of the single judge, that means the order of the appeal court remain. Order of the appeal court remain. Now the present writ petition, the same notifications are challenged. Whatever be the ground, but the same notifications are challenged. Now my lord, first preliminary point is whether that can be done by any other person. After, my lord, because it's a case that, my lord, the entire matter already ended up. Whether this entire matter can be reopened by the single judge.
No.
According to me, it's not. Single judge cannot reopen it, but single judge
Because
can
otherwise,
refer the matter to
if
the larger bench.
we entertain the writ petition, then the matter is to be reopened almost.
No. My submission was,
That whether notification valid or not. And other thing, my lord, in my lord, the affidavit, my
Your
report.
notification dated 18 December 2018 is under challenge.
Yes.
In this writ petition also.
now, my lord, my last occasion, my submission was, my lord, excellent, that it is not open to the London single judge to reopen the issue. The only option available is, my lord, to refer the matter to the larger bench. That's the judgment I had cited.
Now, my lord, in that aspect, my lord, the reference to a larger bench, this is not the, my lord, that there is no, this is for the first time any reference. It can be done. Reference to a larger bench, even by a single judge also can be done. I am not on that. But the question is that when it can be done or when that situation would arise. When it appears, and my lord knows better than me when it appears, that on a particular point of law, if it appears that there are two distinctive or different views of two different coordinate bench, then what should be the law? Then the matter can be referred.
Right.
If before your lordship, my learned friend can place that on the particular challenging the notification, a contrary view has been taken by another coordinate bench, and that is why there is a scope for reference the matter before any larger bench, then I could have understood. It is not such a case. In between the case before my Lord Justice Talukdar, where the judgment delivered and matter went up to the division bench, and it's a merger upwards. It's a merger upwards by the division bench. Then whether in between these, if nothing can be, my lord, crept into by any other judgment, then there is no scope for any reference. Because reference, even division bench can also refer for any larger bench when it appears that two distinctive or different views are expressed with regard to any point of law by two different division bench. Then the third division bench can refer the matter. Actually, division bench cannot refer. Division bench can propose before the Chief Justice for formation of a larger bench. And the then matter can be referred. Here, there is no such occasion. My learned friend has not yet placed any other coordinate bench's judgment or order, which it appears prima facie that contradictory to the judgment or order passed by the other coordinate bench, my Lord Justice Talukdar. Apart from that, my Lord Justice Talukdar order that has been upheld by the division bench, I have, my Lord, annexed to my report also. Apart from that, and
reference should be made by the bench who differs in view,
Right.
not by this bench.
Yes, if your lordship differs with the opinion expressed by the learned single judge or the learned division bench, then the judgment I have cited, there the Honorable Supreme Court's view was deferred by the learned single judge.
Case needs to be reopened, which cannot be done.
No.
Once a division bench has taken a decision.
No. Then that matter can be referred.
Not after the division bench has taken a decision.
Kindly see the judgment I had cited of a coordinate bench, last 2-3 paragraphs. There, the judgment of Honorable Supreme Court was cited, and based on that, the larger bench of our High Court formed an opinion, which was deferred by learned single judge and referred to the larger.
That is when the opinion of the larger bench was cited before that is when you cite other authorities.
That's why, Milad, I have to demonstrate before your lordship that the whatever decision given so far this notification is concerned, without considering the materials which I have placed in my writ petition.
That cannot be, I am afraid, considered by this court because this court cannot sit in appeal.
If no, always cannot. That's why, Milad, if I can demonstrate that the grounds are different, court can refer to the larger.
that this issue has not been decided to this effect. And this court cannot decide it. That's why the matter is being referred to the.
So that because the same notification was under challenge, a decision has been made. So now you cannot challenge the same notification before this court again.
It's reached to five.
No. But may I explain once again? The notification was challenged without demonstrating the grounds that I have challenged in my writ petition. Now I'm coming to that. Now single judge formed an opinion which was subsequently affirmed by the London Division Bench. Now if I can demonstrate before this honorable court that there is a judgment of this honorable court which was not brought to the notice of the learned single judge, then if anybody could bring it to the notice of the learned single judge, the opinion could have been different. Then your lordships can always refer the matter to the larger bench.
Had your opportunity before the single bench?
No. I did not have. I did not have because in that petition I was nobody. I was not party to that proceedings. The proceedings in which the notification has been was assailed, I was not part to that proceedings. Therefore, I had no occasion to demonstrate the grounds I have raised. And my ground is there is a judgment of this honorable court by which the honorable court directed the authorities to form a board so that policy can be framed to avoid any further accident in the metropolitan area. Now, policy was framed in terms of the direction of this honorable court. That policy was challenged before this honorable court. And the policy says the maximum limit would be this. Now, honorable court upheld that policy. Therefore, in terms of the direction of this honorable court, there cannot be more than that, the number of auto rickshaw can ply in a particular route. Without referring those judgment, without referring that policy, all subsequent policies has been framed. Therefore, all policies, whatever has been framed by the state is nullity, because those policies were framed in violation of the direction of this honorable court. Therefore, my challenge is to that regard, that whatever policy you have framed ignoring or negating the judgment of this honorable court is nullity. And that was never placed before the learned single judge nor before the division bench. And that
this judgment with your
I have annexed the policy and the judgment I have brought. Now the policy refers to the judgment, that in terms of the direction of the honorable court, the policy was framed.
Because even if on merits, though I do not want to invite the honorable court to go into the merit, first, let it cross over the objection that I raised. But even then, I think, so far my knowledge goes, I think there is no such order to whereby the power derived under section 74(3)(a) of the Motor Vehicles Act, that power is, my lord, that power is whittled down. Cutting that power or restricting that power, no such order I have not yet, my lord, came across. I have not yet come across. No such order, because whatever that, my lord, the notification, my lord, has been challenged, even on the merit, it appears at page number 145 that, my lord, page number 145, in exercise of power under section 74(3)(a), this power under the Motor Vehicles Act 1988, this is, my lord, with regard to keeping some balance with regard to the, my lord, the need of the public, who, my lord, who would be the commuters of a stage carriage or contact carriage. 71(3)(a) stage carriage, 74(3)(a) contact carriage. And at the same time, my lord, keep in balance with regard to my lord, keep safe from menace of my lord the pollution and my lord congestion and other thing. So the power has been given in this case under section 74(3)(a) that to issue a policy with regard to the number of permits to be given on a specific route or area where more than 5 lakhs people reside. So on that basis, and this power, my lord knows that under the General Clauses Act, possibly my lord General Clauses Act, my lord 24 or 25 clause, that the power once derived from the statute, the executive can exercise that power time to time again and again, which includes modification of any earlier notification also.
Let us see the order of the coordinate bench as referred to by learned counsel. Please give a copy to Mr. Sen.
Let copy I don't have.
It's a reported judge.
Must have. Let.
Justice Dipankar Dutta.
It was reported. It was reported.
2013 GHN.
In SCC online, it was reported. It must have reported in another form. Let him.
My lord, on several occasions, my lord, I have to, my lord, go through the same. Again, I will go through. But my lord, I think, my lord, if I am not wrong, my lord, there is no such embargo that I cannot exercise my power under section 74(3)(a). But my lord, we are prejudiced to my first contention that.
And it was quoted first.
And apart
I have
from
to.
that, my lord, just a minute. Apart from that, in my report, I have also disclosed that a press policy, my lord, after a threadbare discussion, my lord, a press policy may be, my lord, implemented or published very soon. The draft policy is already there. And I have indicated because this policy, this is time to time, it would be changed.
It has to be flexible.
Yes, yes. And my lord, it appears that it may change afterwards. It is also mentioned.
You have a copy of the report?
Yes, I have circulated. I shared.
My humble submission would be it can't be flexible until and unless the area of that.
My lord, internal page 48, running page 159. The last page of that notification. 159. Have you also got it, my lord? Last page.
159.
159. Tomorrow running page. Tomorrow read.
Oh, read it.
Read petition.
Yes.
Now, Lord, have you lordship, my lord, the last but one. Just above the caption order. The government in the transport department shall only be competent to alter or modify this notification from time to time if so considered necessary in public interest.
That is there. I am not on that. My point is very limited.
That is the flexibility.
No, my point is very limited. When court has said.
But deciding you are relying on a judgment. Please show me the judgment.
But first, before I place this judgment, I once again placed the judgment already have cited before your kindly takes up the judgment of Justice Bhattacharya.
Your only issue is that there was a judgment of a coordinate bench. All these notifications are divorce the said judgment. So they cannot stand.
Yes.
And this point was not raised before the single bench or the division bench.
Yes.
That is your primary issue.
Yes.
So please show me that the judgment says that no notification can be made.
Before that, kindly takes up 1 second. Once.
I would first want to see the judgment.
Judgment first.
Where it says that no notification can be made.
It has to be read in detail. But first it quotes the judgment based on which the policy was framed. The paragraph 3 for facility of reference, the notification dated January 29, 2010 in its entirety is reproduced.
Paragraph 3.
Paragraph 3.
my lord, just, my lord, that
একটু
notification.
একটু আমি
totally different.
আমি একটু পড়ে নিই।
That by that notification, my lord, four, my lord, conditions were imposed, whereby and whereunder, despite being the fact that there is a scope to issue notification under section 71(3)(8) or 74(3)(8), still a notification issued by the state government under its executive power to restrain, my lord, the flying of these, my lord, contact carriage vehicles, and there were four conditions, I think. Now that was challenged.
No, uninterrupted চাই।
Uninterrupted.
Amulet, this is important. Whereas the state government in the transport department framed a policy for granting of permits of three-wheeled auto rickshaws under notification so dated 19th October 2004, the main features of which inter alia quoted below. And whereas the government in the transport department has been considering various aspects involving in the matter of issue of granting permits of such type of three-wheeled auto rickshaws, keeping in view the interest and safety of the traveling public in general and the passenger of such three-wheeled in specific vis-a-vis the danger of accidents. This was the consideration from the fast moving vehicles on the national and state highways. Now, therefore, the government in transport department, after considering all the matters as stated herein above, holds that such three-wheeled passengers vehicles cannot be treated as maxi cab for the purpose of granting state carriage permits within the purview of the said notification dated 2004, and district that henceforth no permits to such three-wheeled auto rickshaw shall be granted as indicated below under the category of maxi cab. Then let in route so and so, the government further directs that the granting of three-wheeled auto rickshaw within the particular district only may, however, be considered the concerned RTA of the district after observing all the orders issued by the transport department in regard to the restriction imposed so far in the matters of granting permits to the three-wheeled auto rickshaw, and after taking into consideration the road conditions, congestions of the traffic, and the safety and the security of the passengers traveling in such three-wheeled auto rickshaw as aforesaid, within the ambit and scope of the Motor Vehicles Act 1988 and the rules framed thereunder. The government in the transport department shall only be competent to grant any relaxation in the matter. And whereas His Lordship, the Honorable Justice Topen Chen, passed an order dated so and so, wherein His Lordship observed that the state government should formulate an appropriate policy in the matter pertaining to the grant of auto rickshaw permits in the state. And whereas the state transport department has since considered the matter afresh, taking into view different aspects in respect of such grant or permits of auto rickshaw, namely safety, security of the passengers in the context of growing rate of accidents, traffic congestions, as well as the volume of traffic in different roads in the state. Now, therefore, in consideration of all these aspects, in pursuance to the orders of the Honorable High Court, the Governor is pleased to direct the following guidelines should be followed in respect of granting three-wheeled auto rickshaw permits in the state. No new auto rickshaw permits should be granted in routes and areas falling within the jurisdiction of Kolkata metropolitan area. This is important. No new auto rickshaw permits should be granted in routes and area covering more than one district. No new auto rickshaw permits will be allowed on the national highway except crossing such NHS at recognized points. Plying of new auto rickshaw on state highways shall be restricted up to stretch of maximum 3 kilometers. No new auto rickshaw permits will be issued covering more than 30% of the existing bus routes in the roads other than NHS, SHS. Grants of three-wheel auto rickshaw permits within a particular district only may, however, be considered by the concerned RTA of the district after taking into consideration the road conditions, congestions of the road traffic, and safety and security of the passengers traveling in such three-wheeled auto rickshaw as aforesaid, within the ambit and scope of the Motor Vehicles Act 1988 and the rules framed thereunder. The government in the Transport Department shall only be competent to grant any relaxation in the matter. These orders shall take immediate effect. Bare perusal of the notification would reveal reference to an order dated so and so, passed by the Honorable Justice Topen Chen while considering WM so and so. It would be necessary to note what his lordship exactly directed. Hence, such order is quoted verbatim hereunder. Having heard the parties of this court is of the view that the matter pertaining to grant of auto rickshaw permits on the routes Mamzo, Ghat Swanso and Ramnagar vis-a-vis Swanso area requires a consideration by the Regional Transport Authority, Nadia. The reasons why this court feels that there should be a reconsideration is because the application has been rejected on 3 grounds. 2 of such grounds, namely ones pertaining to not furnishing garage details and not supplying proof of financial stability, having already been decided by this court in a number of writ petitions in being so and so. Consequently, this court is of the view that so far of these 2 grounds are concerned, the authorities should reconsider the matter in the light of the observation made herein above. So far the 3rd grounds is concerned, it appears the authorities have stated that route applied for is a bus route on the basis of the ground as well as 2 methods above. The authorities proceeded to reject the application for grant of an auto rickshaw permits. The learned counsel for the petitioner submitted that the statute nowhere lays down that an application for an auto rickshaw permit shall be rejected if a portion and or the route applied for by the said auto rickshaw overlaps the route traversed by a bus. The learned counsel for the state could not dispute such a contention. Under such circumstances, the rejection of application on such a ground alien to the statute, unless the state government frames a policy laying down qualifications and criteria for grant of an auto rickshaw permits, a regional authority on its own cannot take such decision. It is true that if the auto rickshaws are allowed to ply on bus routes, there may be a severe traffic congestions or risk to the safety of the passengers traveling in such auto rickshaw. But unless the state government formulates a policy, the rejection by the authority on the ground which is not within the policy of the state nor within the statute cannot be allowed to be sustained. Accordingly, order and or the resolution of the Regional Transport Authority Nadia is taken on so and so is set aside. The matter is remanded to the said authority for reconsideration for taking fresh decision in accordance with law within a period of so and so. Simultaneously, let a plain photocopy of this order be handed over to the Land Advocate General for taking up the matter within the government for consideration the desirability of framing an appropriate policy in the matter pertaining to the grant of auto rickshaw permits. Within the aforesaid observation, the writ petition was disposed of. Subject to an application for certificate copy so and so. Now let paragraph 8, referring to the provisions of the Motor Vehicles Act, Mr. Das contended that the power to grant permits is vested in the state transport authorities, West Bengal, and on each of the RTS constituted for the government to limit the number of permits to be granted, be it stage carriage or contract carriage only, by a notification in the official gazette. And that too on the directions of the central government, as would appear from the section 17(1)(3) and 74(3) of the MB Act, that the power to frame rules has been given to the state government for controlling the vehicular traffic. That power has been given by Rule 88 of the West Bengal Motor Vehicles Rules 1989 to the STA to frame policy for control and coordination of the road transport. That unless the rule is framed by yes, that was considered. These provisions, provisions was cited. The provisions my line friend was citing that was that referred to while considering the judgment, paragraph 15. Having heard the parties at length, the first question that the court is called upon to answer is whether the notification dated January 29, 2010 is valid in the law or not. Should be answered in the negative, and it is declared ultra vires that the impugned resolution of the respective RTS rejecting the application for permits of the petitioners are likely to fall through. On the other hand, if the question is answered in affirmative, each of the impugned resolutions of the RTA would have to be taken up for consideration individually to ascertain whether the terms of the notification dated January 29, 2010 have been correctly applied or not in rejecting the application for permits. The Constitution of India is the supreme law. It is the foundation head of all the laws. It is well recognized by now that the act of parliament or the state legislature could be challenged and set at naught as ultra vires if it is established that either parliament or the legislature, as the case may be, was not conferred by the power by the Constitution to legislate on the subject matter of the relevant legislation. And second, the subject legislation is unconstitutional on the touchstone of Article 14 of the Constitution. Similarly, the subordinate legislation or an instruction issued by the central government or state government in exercise of executive power, which is found to be to foul the parent enactment of the Constitution, can also be declared ultra vires. These principles have not been disputed at the bar. MV Act is a central legislation which has been enacted by the parliament having this was dealt with in detail.
Discussions. Come to the observations.
Yes, Matt.
These are the discussions. Please come to the observations.
Now, then kindly turn to paragraph 30 onwards. The sentence starts with, apart from the facts of exercise of executive power of the state in issuing the impugned notification to regulate the policy in respect of grant of auto rickshaw permits, which does not condemn to me to be an act either upon assumption of authority which the law does not confer or in excess of the authority conferred, there is one other aspect that can never be lost sight of, and that is the order dated so-and-so of Honorable Justice Topenchen. The state was bound to implement the direction contained therein. Assuming arguendo and that the state exercised an authority which it never possessed or in excess of what has been conferred, the judicial order of this court without anything more acts as the protective shield and insulates the impugned notification from being interfered with, so long the judicial order is not wiped out of its existence. Therefore, justice, whatever policy was framed, the question was raised that this is without authority. Act does not empower the executives to frame such a policy. Court says, no, if there is no powers, the order of judicial order is there. Until the order is there and it is not set aside, you cannot challenge that notification. The next, I propose to examine whether the impugned notification is ultra vires to the MP Act. If so, to what extent? This was ultimately answered in favor of the notification. I can read it if you so desires. Therefore,
that doesn't come to your aid.
Yes. Because the notification that was framed in terms of the direction of Justice Topenchen was upheld by the Honorable Court, which was challenged by the different person aggrieved. Therefore, as of now, that notification, unless this order is assailed in division bench and set aside, nobody can by exercising judicial executive order, power, my lord, can negate this judgment by which the notification was upheld.
Just come to the order of Justice Sen once again.
Justice Sen, the perspective was to avoid congestion, to avoid and to ensure safety, you frame a policy. That is the crux of the order.
A reconsideration was directed.
Reconsideration perspective was ensure safety of the passengers and let ensure that there is no congestion. Frame a policy, because there was rejections, instances of rejection by different RTS on different grounds. There was no uniformity in rejections. That was the context. It was sent for reconsideration and further directed to frame a policy. And policy was framed that no auto rickshaw should be granted in the area which is within the metropolitan area of this state.
There was no direction for framing of a policy by Justice Sen.
Yes.
It was only a direction for reconsideration.
No. Kindly see. Yes, ma'am. Well, I'm just reading the relevant part. Previously, it was also recorded. Second last paragraph of the order. Simultaneously, let plain photocopy of this order be handed over and served upon the Land Advocate General of the State of West Bengal for consideration of the observation made above and for taking up the matter with the government for considering the desirability of framing an appropriate policy in the matter pertaining to the grant of auto rickshaw permits. That's why Justice Dipankar Datta says, if there is no authority, the argument was the Act does not permit the state to frame such a policy. The competence was under challenge. Justice Dipankar Datta says, even if I assume the Act does not empower the executives to frame such a policy, the order of Justice Tapan is there to shield it until and unless the order of Justice Sen is set aside. You cannot say that the policy is without jurisdiction. Now that paragraph I have just read. That is paragraph 30 of the judgment. Now, may I read once again?
For considering the desirability of framing an appropriate policy.
Yes. And the context has been recorded earlier. Safety and all that. And that's why Justice Datta, while considering the policy, the challenge to the policy, the competence of the authority to frame such a policy, that was the argument, that beyond the scope of the state authorities to frame such a policy. And Justice Datta observed that so long, may I read the line once again. Apart from the facts of exercising of executive power of the state in issuing the impugned notification to regulate the policy in respect of grant of auto rickshaw permits, which does not commend to me to be an act either upon assumption of authority which the law does not confer or in excess of the authority conferred, there is one other aspect that can never be lost sight of. That is the order dated January 5, 2010 of Justice Tapan. The state government was bound to implement the direction contained therein, assuming arguendo that the state exercised an authority which it never possessed or in excess of what has been conferred. The judicial order of this court, without anything more, acts as a protective shield and insulates the impugned notification from being interfered with, so long the judicial order is not wiped out of its existence. Now, that is the observation of a single judge, and that was nobody has assailed it in division bench. Therefore, it is categorically observed, even if the power is not there in the statute, judicial order protects the notification.
This is with regard to a particular notification of.
Right. And that notification says no further auto rickshaw in the metropolitan area. Now, that notification was upheld by this court. Now, so long this judicial order is there, now this is not a mere notification. This was assailed and upheld by this court.
Still a notification, sir.
Still a notification which is safeguarded by a notification order of this court. And so long this observation is there, that notification prevails.
It is not ultra virus, that is the observation.
Yes. Therefore, if the authority want to increase the number of auto rickshaw, they have to first cross this hurdle of this judgment. Without referring to this judgment,
Says that the government can, is competent to grant any relaxation to the notification. This line has also been upheld by the court.
then it has to be considered that there is deliberation. And unless that deliberation is there,
Challenges to relaxation of the
uh,
notification. By this judgment itself.
yes.
So there is no question of reference.
Now kindly see. Kindly see then, if the excise part of the last line of the notification, the government can relax, then there must be a notification that in exercise of power of the statute or so and so, they are relaxing the terms and conditions made herein. That should be the notification. Now, kindly see the impugned notifications. This does not even refer to this notification. The first notification, kindly see.
Referring to the earlier notification is mandatory. When the government has power to relax, it can relax.
It can relax.
Without stating that this is a relaxation with the earlier.
That is not their case that they are relaxing. Rather, kindly see the policy at page 72. What is their policy? This is not at all relaxation.
Bench restrict the government from further notification or any subsequent notification. That is your point. That is your issue. This judgment. And this point was not raised before the single bench or the division bench. How do you justify this?
This notification, in detail considered the issue relating to congestions and the safety and security. 2 minutes. Safety and security of the passengers. That was the consideration. That is the consideration. That is on the record. That is the objective consideration that has been applied by the authority, and that was challenged.
Has been dealt with by the other benches and
no, whether yes, that this was the background on which the notification was issued.
Cannot be the background was this announced relaxation.
No, relaxation is something else. Relaxation does not mean changing the policy in its entirety. Relaxation means the reasons has to be recorded, and the relaxation has to be recorded, considering the parent reasons and objectives of the notification. This is the only policy that was framed pursuant to the direction of this court to ensure safety and security of the. May I take leave?
May I just go your lordship? Just my lord, so far, my lord, if you lordship, I think my lord is not going to merit in the matter. But then, my lord, first challenge, lordship, kindly, my lord, come to page number 88. I think, my lord, it should draw your lordship kind attention. Page number 88, because two policy or notifications have been challenged here. One is, my lord, page number 88. It was also challenged before the coordinate with my lord Justice Talukdar, page number 88.
Yes.
In the writ petition, P7. Now, my lord, these, my lord, notifications, it carries 14th August 2018 date. At the top.
Only this notification was challenged.
No, here, in this writ petition, notifications have been challenged. One is, lordship, kindly have a look, page number 30, page number 88, 14th August 2018. This is one auto policy. Have you lordship got it, my lord?
Yes.
My lord, by this auto policy, if you lordship kindly come to next page, Roman 2, policy for regularization of unauthorized auto rickshaw. Those without having permit have been plying their vehicle unauthorizedly. By this policy, and window was opened to regularize the same up to a certain period. Now, this was also challenged in that earlier writ petition.
In the earlier petition, only this was challenged.
Only this was challenged. This was challenged. Now, my lord, lordship, kindly, no, including the other notification also, whereby section 74(3)(a) in exercise of power, my lord, that was, my lord, the cap was, my lord, fixed with regard to number of permits.
But in the earlier petition, I find only one notification was challenged. Only the August 18 notification was challenged.
Only, lordship, that is 3944.
August 18 notification, it has not been numbered here.
Yes.
14th
18
August, 14th August
August,
notification
yes,
was challenged.
yes, 14th August notification
Not the other two notifications.
and other, I see. But
This notification is in supersession of the other two.
now this notification, 14th August notification, my lord, kindly come to my lord, page 89. My lord, the life was up to 31st December 2018. The last, my lord, the Roman X. The process of regularization of existing unauthorized auto rickshaw in the state following the above step is to be completed within 31st December 2018. After this, my lord, so far this regularization process policy, my lord, it has, my lord, no validity. So whatever the regulation done, this notification, my lord, no more, my lord, valid after this. And my lord, so far, the other notification, if you lordship kindly come to once again, lordship, the next notification, that is of 10 December.
Dealt with by both the benches.
Yes, number 10 December 2018 notification. Number a challenge before your lordship is that in view of 29 January 2010 notification, which was challenged before my Lord Justice Dotto. One of the page number 91, it starts page number 91 notification, which is challenged.
The petition bench refers to notification December 20. Not the August notification at all.
But it was also, my lord, within the, my lord, have you lost, I think the, my lord, the copy of the writ petition are filed. Your lordship.
Yes.
That copy of the writ petition is not with me.
The
That
order is
early-
here. The copy of the writ petition is not here actually.
No, my lord, I think that file before your lordship, my lord, I am told that.
The orders are filed, not the writ petition. And the orders did not actually mention the notification.
My lord, the order of Justice Talukdar, I will also say, my lord, my report.
But the notification is 18th December, yes. So even if it is taken,
5820 of 2019 was the writ petition.
yes, that is with regard to the 14th August notification. What about the other two notifications?
14th August 2018,
Yes,
read with 18 December 2018.
yes, yes.
Now,
But there are two other notifications referred to here. One is 10th December, one is 31st March.
yes. December 2018 notification is also challenged herein. If you
Yes,
also
these two
kindly
have
come
been
to
dealt with.
page 144.
These two have been dealt with.
Yes, so 18 December 2018 notification, that is at page 144. It was the subject matter of the writ petition, earlier writ petition. And at the same time, the notification of auto policy, another notification that was, my lord, with regard to regularization policy, that was also challenged. And it drew a lawsuit's line attention, my lord, at page. That is at page 88 possible.
88 is the August notification.
14th August 2018.
That has been dealt with.
So 14th August 2018 notification, whereby and whereunder an window was open for a limited period to regularize the unauthorized auto rickshaw which were plying at that point of time. That was challenged. And at the same time, challenge was thrown to the notification, my lord, that is, my lord, 18 December 2018 at page 144.
Said these two notifications were dealt with,
Yes.
chapter closed. We cannot reopen it
Fine.
here. But there are two other notifications challenged in this writ petition.
Two other notifications, lordship, that
What
is,
are they? One is 10th December 2018. The other is 31st March 2017.
in December,
Prayers B and C.
home page আছে।
What are these notifications? Prayer B and C.
In December,
The petitioner should be able to apprise.
in December 2018.
Page 7.
Page 91. 91.
Oh, 10th December and 18th December are the same notification.
Same.
There is a 2017 notification also.
91.
10 December, the same.
Yes, they are the same.
Yes.
But there is another notification. 31st March 2017. Prayers.
31st March 2017 is no more, my lord, because after these notification, those notification, even if, my lord, if your lordship, my lord, set aside the same.
Supersession.
So yes, my lord, it would appear from আমি দেখেছি in supersession আমি দেখেছি।
Is it recorded in the? One 59 is not legible at all.
It is in supersession. It has now become state. Including partial modification of 2008.
Yes, page
notification
145.
also,
Yes, page 145 says in supersession.
Grateful to your lordship.
31st March.
Yes, very much grateful to your lordship. Page 145 at the top. In exercise of power in supersession of, yes, 31st March. So nothing
Let
remains.
there be an order, yes, on the minimum condition. Learned counsels for the cause. The notifications issued on August 14, 2018, December 10/18, and March 31, 2017. March 31, 2017 are the same. The notification issued on December 18, 2018 demonstrates that the same was issued in supersession of the notification number 1276-4M-23/95T Roman numeral. Dated 31st March 2017. Therefore, the notification dated 31st March 2017 is challenging the notifications dated August 15 and September 20. Type by an order passed on five said order was carried in appeal and by an order in LAD 562 of 2019. With 126 bench of this court. Modified the income notifications and of the same by using a directed implementation of the same by the government by using their discretion reasonably fairly, fairly practicing any malicious discrimination between the new auto rickshaw and the unauthorized auto rickshaw in registration under the impute. By this code. Principle of his claim, the counsel petition of substance. Earlier orders were passed. Therefore, of the school. Batch of repetitions. For the service. This code. Is reliance on an order passed in Five 2010. By affordable wages. Directed consider the desirability of creative policy. The grant of Interfere with the by the government on 29th January. Down. Child rights. Respect of granting permits for three-wheeled vehicles. Twenty-ninth January. It's a 2018, December 2018. Right? Judgment passed in the judgment date of March 28, 2024. That the government, the transport department shall only be competent to grant any less the matter. Stop. Therefore, there is subsequent since the notification established in the and decided upon Are dismissed, comma, being not maintainable. There shall however be no rest. There is a second repetition also. What is the prayer in it? Copy or done. 14:8 and 18:12. Just copy it. এটা ফাল্গুনিটা যেটাতে আমরা সাবমিশন করছি ডিভিশন মেনশন
WPA 10,525
এটা আমাদের এটা হচ্ছে আরেকটা রিপিটিশন
5280.
এক্স্যাক্টলি ফাল্গুনিটা
My lord, only repetition that is before my lord is WPA, but it was right now WPA 10525 of 2020.
along with 5280.
No, 5280 W of 2019 already earlier repetition already disposed of by my lord Justice Talukdar.
Reference file.
Reference file. Reference file.
Next one.
Get.
Reference file list লিখে দিতে হবে।
হ্যাঁ, না, না, না। জুনিয়রের নামটা দিয়ে দিয়েছে
Number 65.
তো না না, আমি নেবো আছে বলতে পারো PS3 vehicle matter.
Yes, only. Big man, it will continue.
It will take some time for the day.
3:30 to আছে।
দাদা আছে কি 65 করছিস তো
কি বলেন
You have completed your submission.
Yes.
Don't the expect was directed by the because it coordinates its order in there.
Coordinate.
I am covered by the Honorable Supreme Court judge.
Years and
15
yes.
And the notification that public is enter party, but
This is registration.
PS3 vehicle.
Registration. Not grant of permit.
No. The registration. Registration regarding replacement.
This is grant of permit.
This is a grant of permit. Grant of permit, my lordship, kindly see in view of the present notification, my lord. It is 1st of March.
Is it your report?
Yes.
Additional report.
Second report দিয়েছে না?
এটা তো ওকে এখানে সারা একটা
Deborah, are you ready?
No, Bharat.
Report is not with me. Why was? Why is there? Report টা আছে তোর কাছে?
That's the additional report.
Yes.
Mr. Devra doesn't seem to be ready to
Because,
come back on a short date. Everyone is.
yes. Lordship can fix another date, madam. Yes.
Because it's a very short matter, it's not a very long matter, so please.
Oh, হ্যাঁ। একটু আমার ছেড়ে তাহলে আমি ঠিক আছে।
Clarify the distinctions, that's.
My lord. But so fixed any day, your convenience, your lordship.
Respondents that actually sent it, same.
আমাদের কার্ডটা শেষ করে দিন। এটাই রয়েছে।
10 to 60.
চলে গেছে।
Very well, 23rd June. 23rd June.
অনেক সময় পেলেন। না ও দেখো না। ও এটা ওই বিপে চলে গেছিল। Next matter is Mr. Nayak, but that people are carrying this, that's why I am not available. 23rd June, I said.
Item 66.
65 and 66.
একই তো matter.
Same matter.
Same identical matter, two matters.
So let the same order be passed,
Same order, why?
Same order, but separately with a separate number.
Yes.
সেটা তো আলাদা।
ওটা কি আপনি স্টেট?
হ্যাঁ।
Slip দিয়ে দিয়েছি।
হ্যাঁ। দেখো তো। না টাইম হয়ে গেছে। About 5 or 7 minutes.
Sir, then.
1 minute, sir.
23rd.
কে আছে others?
Release the other matters. I shouldn't have. It is being taken up, it's in the first few matters only. I thought Mr. Devra will take some time, so
I am not available, the report lying with the brief of Mr. Nayak. Oh. Thank you.